30th July, plea of life. Same melody listed for orders, melody.
Which year?
Melody 24 melody that appeal is admitted. I for suspension of sentence. Melody already amicus curiae appointed melody last month.
Okay.
Next week attend.
Yes.
Item number 13.
Item number
13 loaded.
13.
13 1 field.
Yes.
Matter has come up for order for suspension of sentence.
Yes.
Today my senior has some particular difficulty.
Yes, madam.
Yeah.
On a
I
request.
have taken consent from the other side.
Okay. On a request made on behalf of the applicant, matter is adjourned to be listed after a week.
Thank you.
One three. Item 15 and 16.
Paid cases. In this matter, personal appearance of the respondent was called for. The Lordship may kindly have a look at the order. It is 16/7/2025.
Yes, we remember this matter.
Yes, my lord. In spite of several orders, she as on date has not appeared before this honorable court, my lord. Lordship may kindly have a look, my lord.
Okay.
Order it is 16/7, second paragraph. On 18/6/2025, this court, for the reasons recorded therein, had to issue a bailable warrant of arrest.
And we have seen this. He's been continuously defaulting. Not only defaulting, willingly. After being served also. And it's a contempt matter. He has not specified the order of the court, then contempt came, contempt has been served, yet not appearing. You have to issue, and the last order, last paragraph. Yes. We issue NBW then. Heard Ms. B. Bhuya, Learned Senior Counsel, assisted by Sri J. Das for the petitioner. In this matter, though notice was served upon the sole respondent, neither there was any appearance nor any cause shown. After giving sufficient opportunity, this court had passed an order on 18/6/2025, issuing bailable warrant of arrest, fixing 16/7/2025 for appearance. Full stop. Those steps were taken and the bailable warrant of arrest was issued on 26/2025. The respondent did not appear on the date fixed, that is 16/7/2025. When this matter had come up for consideration, had come up for consideration on 16/7/2025, in the interest of justice, another opportunity was granted to the respondent for her personal appearance, fixing today. It was further observed that in the event of non-appearance of the respondent, this court would consider the option of issuing non-bailable warrant of arrest to secure the appearance of the respondent. Full stop. Even today, the respondent has neither appeared in person nor through any counsel. Full stop. Under the aforesaid situation, this court is of the opinion that to maintain the sanctity of the judicial system, And in a system, comma, non-bailable warrant of arrest be issued against the respondent, directing execution against the respondent, full stop. Let the next date be fixed on the 23rd. We can have it on 8th. 8th of, no, 8th would be 23rd. We can have it on 13th of, it will be too late. Non-bailable. We can have it on 6th also, 6th. 2 weeks. No, 6th of August 2025. Registry to take all necessary steps for implementation of the present order.
There's a appeal also, order, as there has been. Okay.
10:30. Was I deemed to order? Yes, matrimonial. What is it? Sadaka, you are the
I'm for the husband lot.
first party.
First part.
Your application for divorce has been rejected.
Yes, sir. Not divorce.
No. He pronounced talak, my lord. I challenged that, my lord. Talak was stated.
No, you said you are the first party.
Yes, I'm the appellant lot.
Oh, not the first party. Say
he
you are
said
the appellant.
Oh, yes,
The
sir.
appellate
I'm
court
the
is not
respondent.
first party.
Yes.
You are the second party there.
Yes, sir.
You are aggrieved by the.
Yes, sir.
Okay. Aggrieved by which order?
It's 13 months.
1-3.
Order dated 27/2007.
Lordship, basically in this case, Lordship, the court has set aside this order because the mediation before the Qazi was not followed. Mediation process before the Qazi was not followed. That is the finding of the court.
Okay, we since it has come under a special drive, we'll have this for mediation. Okay, আমি বিপ্লবে একটা order মারি দিস একটু হেরি করে দিব 18th it will fix on 18th
18th of
18th of
August.
no, we'll fix another date. All we 18th that will be difficult. Today we'll have it 19th, all the cases. 19th, huh? And date, do you have any mediator of your choice? Both of you?
They are from Guwahati, my lord. No problem.
No,
19th.
mediator.
Mediate, no one.
Lordship,
Any
19th,
mediate.
Lordship, 19th for mediation.
Yes. No, not 19th for mediation. 19th is the next date. Mediator will give a date in between,
In between.
make a preliminary report, give us on 19th. If we feel, we'll give further time. Okay?
Lordship, 19th I will not be available. If possible, Lordship, on 21st.
19th is only for consideration of the preliminary report. You'll have somebody. Okay. We'll try to have it in the same day because all these matters will give. What about Yusuf Mannan? Okay. Yusuf Mannan, huh? Then you have to give copies of all the relevant documents within 3 days. He will give notice through you. Okay. We have an order already done. Day before yesterday. Okay.
We have to give all the set of the documents.
Yes, both of you set up the documents to the learned mediator. Within 3 days, he will give you a date for appearance to the parties through you. And the next date in the court will be on 19th of August where, before which preliminary report will be given by the mediator, depending on which we'll pass further orders. Okay.
Highly appreciate. Okay.
Item 2. What is the matter about?
But it is I am the appellant matter, appellant wife matter, the dictator type of event matter. And against that I have come to police for fight. Now reunion is not possible, my lord.
Hmm?
Now reunion is not possible.
No, reunion, mediation doesn't mean reunion.
We also-
Mediation means settlement of the matter once and for all.
Yes, my lord.
You can separate in a very dignified manner, but you sit for mediation. Yes, madam, any mediator of your choice?
No.
We have Anupama Devi. Okay. Same 19th, same order. We propose. Okay.
My lord, there is a order of earlier person matter. Some pending maintenance for there.
That will not touch today. This is listed on a special head.
If they want,
And-
my lord.
And advise your client to appear with a positive mind to settle the matter.
Yes, my lord.
Okay. Next. 3. Yes. Other side appeared. Yes. What is the matter?
Against dissolution of marriage.
Against dissolution. You are the.
One to must try against it.
No, we'll try. You are the wife.
Yes, I'm.
The divorce petition was filed by Mr. Deka. Allowed.
Allow them, permanent that 5 lakhs.
Okay. Okay.
That we have said.
Okay. Yes, anyone whom both of you agree upon? We give you a choice.
Yes.
If not, then we appoint on our own. We find the name of Sangeeta Khatun here. We cannot appoint her. She'll be biased. Wholly biased. Okay, we appoint Meghali Burman.
Yes.
19th is the next date.
Right.
Yes.
Apply.
The orders are ready. We'll have it. আর নামবিলাক দেখিবা কিন্তু চবৰে পি বৰ্মন ডেকা পি কে ডেকা আগৰবিলাকতো লিখিবা দেই আগত মন পৰিছনে প্ৰথমটোত আছিলে তোমাৰ হেৰি পি ডেকা আৰ আলি ছেকেণ্ডটোত আছিলে বি পি সিনহা এণ্ড পি চক্ৰৱৰ্তী থাৰ্ডটোত পি বৰ্মন পি কে ডেকা অ'কে নেক্সট
If it's a lordship, the cost, my name is Pune, Pune, but I am not a council for the Pune. I wanted to record the photos also my name is Pune A. Acharya, but there was a delay. The delay, the B. Acharya was that
Who?
B. Acharya.
B. Acharya. Is he aware of this matter?
I don't think so. Not
B. Acharya, what is his full name?
Nayak Acharya. I'm not sure.
See, sending before the mediator without the council's
Yes,
being informed will not be. Can you inform?
My lord, according to him, my lord, P. Acharya's name is not so. My lord, he submitted the wakalat. Yes,
That
my
I
lord.
understood. Do you know Mr. B. Acharya?
Once, my lord, he contested another case with me. I know.
Oh, you have his phone number.
Yes. No, my lord. I will collect, my lord.
You try to collect. We can have it after some time, or otherwise we can have this on the Friday. Okay. Because order of mediation has to be passed in presence of the council for the parties, so that information is passed. Otherwise,
Fine.
no.
Fine.
We'll have this on Friday. Okay. Do
my name
3
is
a.m. Borbia. learned counsel is present for the appellant, it appears that, 3 AM Borbhaya, and heard 3 AM Borbhaya learned counsel for the appellant, para. 3A Acharya, learned counsel, whose name appears in the cause list, has however submitted that he is not the counsel for the respondent, and the records would reveal that one B Acharya
Yeah.
is the counsel. Para. List this case again on Friday by reflecting the correct name of the learned counsel for the respondent as B Acharya.
Fine.
You also
Yes, sir.
contact him.
Okay, keep look.
Identify. Laskar, other side,
That it possibly shown that
M.K. Sharma, K.K. Goswami.
that in this fellowship, the learned principal judge of the family court resolved the marriage tie between the
No, that is okay. We are on a different purpose today.
Yep.
Can you inform, do you know the counsel?
I have no contact of him.
If you can find them, bring them, otherwise we'll have this on Friday. Try, because you cannot send it for mediation without the presence of the counsel.
Yes.
Now sending notice again by the mediator is not the object. Heard Sri N.H. Laskar learned counsel for the petitioner. Also, however, there is no representation on behalf of the respondent. Do names of the counsel, learned counsel, appear in the cause list, para? In the interest of justice, list a matter is adjourned to be listed on Friday.
Yes.
Please try to inform them.
Yes, I know.
Item 6.
May please,
Oh, here it লাগিব.
secretary appeal
Here
counsel.
লাগিব. Your legal aid counsel.
Yes.
Conviction under
Section 305.
why have you made the informant a party again? 302 unnecessary.
I said
Earlier, this is not earlier. No, since you have made parties, we will not delete. You have to take steps unnecessarily. Making things lengthy, okay. Legal aid counsel, huh? This is S. Khatania, legal aid or Mariba, admit, call for the records. 1 R.R. Kaushik, steps for service of notice upon the respondent to in the manner prescribed. It is routed through Nalagaro, huh? Poxo no it. 6 weeks for service report as well as for report on receipt of records as well as service upon the respondent to. As on to Marisa legal aid, okay.
yeah, so
I issue notice, huh? This is an application so and so issue notice. The connected appeal has been admitted, Likhiba. Isn't it? Okay. R.R. Kaushik, APP. Yes, next. Item 7.
Yes, my lord.
Yes, please.
Yes, my lord. The conviction was
Poxo is
15
there.
years.
Poxo,
Yes.
okay. You are S. Ahmed.
My-
S. Ahmed, huh? Poxo, admit. 1, call for the record. 1, R.R. Kaushik. 2, in the manner prescribed, which is to be routed through the office of the public prosecutor, Assam. ठीक है sir? That's a 6 weeks for service for records as well as service report. Okay. You have an IA also?
Not
No.
of it.
You don't have IA?
No, I have not filed IMI. In the meantime, I will file. Published.
8.
So,
It is Poxo. What is your name?
Yes,
Hmm?
yes, I know.
A Saha. A Saha, huh? A Saha, AKC motor, R.R. Kaushik, number 22. To be routed through, huh? You have to take steps. Okay. Steps within 3 days, whatever. You don't follow correct the same. Yes, madam.
Your Lordship, I have challenged the impugned order dated 16/5/2020.
Conviction under what?
Kindly
Conviction
see your
under,
Lordship, another one,
conviction under what? Which section?
conviction is under section 279 IPC and 304 IPC.
But the conviction is simple imprisonment.
Simple imprisonment for?
But as per there, my lord,
Then why is it
16,
division bench?
as per
And 2 years also.
2 years. That's wrong.
Huh? Wrongly still go for a single bench. And you would be, are you on bail? You get the information.
I'm a senior secretary.
Okay. Why is it listed?
In the
before
meantime,
this?
your Lordship, kindly pass over the tactics.
No, we'll have it listed before the appropriate bench. Considering the nature of the conviction and sentencing, it appears that this this appeal is to be listed before the single bench. Para, registry to verify and list the same before the appropriate bench expeditiously.
Yes, Your
Why is it listed? Is there anything else, Mr. Kaushik? Why the registries do such a blunder?
I didn't find anything.
Para 7, number 10. Is there a note or something? Where is the division bench? Huh? This one? Stem nine? It would nine. It would nine. Oh, full case. I'll go before the appropriate bench. Yes. Yes, next. Item?
Is convicted under 21(3) of the NDPS Act, the appellant. Sentence is 12.
Conviction of what is the sentence?
Sentence is 12 years and to pay a fine of ₹1 lakh.
Okay. You are M. Ahmed.
Yes.
Huh? Admit, huh? Call for the records. Mr. Kaushik will be accepting notice.
Proof.
What about two? What about two?
Please.
I got,
SI of police. Why do you have you made him party?
The informant.
Why?
that's correct.
Why is
Okay, may I
it?
strike it out.
Huh? Well, on oral prayer, it's difficult to strike it off nowadays.
Okay, I'll file an appropriate application.
You can accept notice. What is the
But
difficulty?
otherwise, that's read as a process.
By name.
No, no, no. No, yes.
By name.
By
By
name,
name.
That-
SI so. You have to take steps then on two steps in the usual process. For two. One RR Kaushik. Okay. Item 10, 4 orders.
Here,
Burman is unwell or what?
Burman was appointed by us.
Not well.
Personally, deal.
Okay. Paper book prepared.
It is not received paper book.
TCR has not been received. What is it?
Pro-
I see. Um, uh,
20
okay. Office note dated 23/4/2025 reflects that the TCR has been TCRS have been received. Where office is directed to prepare the paper book and thereafter list this case for orders.
picture.
11. Yes, Mr. Chaudhary, what is
Ma'am,
this?
please allow. We had taken steps okay, for the service of respondent number to the OC concern as per the office note dated 25/2025.
Hmm.
Have been taken.
But I tried to get the information from the service or not. Yet. So, not yet.
Okay, we grant some more time. Okay. Though the paper book has been prepared, the aspect of service upon the respondent number 2 is yet to be ascertained. Para. On the prayer of Sri R. Kaushik, learned APP Assam, matter is adjourned by 2 weeks to enable him to obtain necessary instructions.
Other
1 week if you say 10 days. 10 days.
DPO.
Item 12.
Well, Mr. Dotto, I am Dotto. Appeal was admitted. Thereafter, what has happened?
Yeah.
You're
I-
amicus.
I could not verify the record. If there is there,
Hmm?
if there is there,
What about the aspect? What conviction under what sections?
Dr. I could not verify the record. I just
Oh, first time your name has
First time.
come. Okay, it's a POXO matter.
popped up.
POXO. Oh. Okay. Pursuant to the order of admission dated 25/10/2024, 3 AM Dotto, who was appointed as an amicus curiae, is present. Wow. The TCRS have also been received. Para. However, there is no certain report. There is no report regarding the service of notice upon the respondent number 2, though the same was issued by speed post on 23/6/2025. Miss A. Begum, learned APP, shall obtain necessary instructions from the concerned PS regarding service of notice upon the respondent number 2. 10 days time, madam? 10 days. Within a period of 10 days. List after 10 days.
Master file. Paper.
In the mean, we also direct, and since the TCRS have been received, we also direct the office to go ahead with the preparation of the paper book.
Master.
Sir, on the day when we moved this criminal appeal, there were 4 accused. 2 were sentenced to life, the son and the father. And the other 2, since they were sentenced to only 8 years imprisonment, we segregated them and now it is registered as a separate criminal appeal and it will be listed before the
Single bench. Okay.
Now, on the day 1, my lord, we have taken a plea of juvenile. So far, one of the accused is concerned. But because your lordship is aware that we can take the plea of juvenile at any stage,
Yes.
even after the pronouncement
Yes.
of the judge.
Yes.
And accordingly, this honorable court directed the district and session judge Dhubri to conduct an inquiry.
Okay.
And we, during the inquiry proceeding, we relied on a birth certificate issued by the Jubilee Civil Hospital. Now, when the learned session just made further inquiry in regard to that birth certificate,
Age factor.
age factor, it transpired that that it contained the seal and the impression of the district Jubilee Civil Hospital. But he came into opinion that it is a forged and fake. Why? Because in the year 1999, when this certificate was issued, there was no procedure for such issuance of certificate. He has not nobody has stated that this seal and all are forged, or there was no inquiry in that regard. Now, normally in a case of juvenile, your lordship knows because this will be under the 2000 Act and rule. Subsequently, in 2015, the Juvenile Act has been amended. Now, when a plea of juvenility is taken, who is in conflict with law, there are several criteria to determine the age. Since one of the criteria has failed, the learned session judge, with utmost respect, ought to have to resort to the other method to determine the age.
Under 94.
Yes. Now, 94 under the new act, it is the same parameter with the old act, it is under the rules, the same procedure. He should have resorted to that and at least conduct an ossification or radiological test. So your lordship will direct the district and session judge to conduct an inquiry in that regard by following that rule, or he may form a medical report to determine the ossification test, because that will at least give a presumption, either way plus minus 2, to know the exact age of the this juvenile in conflict with law. Because your lordship, it is my duty to point out before this honorable court that when the forwarding report was prepared by the police, the age was given as 29, 19, just to make him a measure. But when the statement under section 313 was recorded by the learned trial court, 2000 Contempt. 2000. 94 is perimeter with the old act. The procedure is given in the 94. But since this is an offense of 2013, the old act of 2000 will be applicable.
No, this is the same.
The same.
Contents is the same.
Content is the same. Under the old act, this 94 was under Rule 12, 2000 Act. Now it has been amalgamated and made into section 94 of the 2015 Act. এখন প্রিয় This is under the old act, this is Rule 12 of the 2007 rules.
Now it has been made a section in the main act.
Yeah, main act, the same procedure. Your lordship may observe that this is perimeter. So he has to resort it to the other method which has been given under the Juvenile Justice Care and Protection of Children Rules 2007, to determine the age. So 94(2) is the relevant in the new act, my lord. 94(2).
No, see, we have not even heard Madam Bhuya, but these three options.
Yeah.
It is the options given to you. You may have a birth certificate. You may have a school certificate.
Yeah.
If neither of those are available,
Yeah.
you go to the third. Ossification is the last option.
We want to go for the last.
No. Now it's not a case that you do not have.
No, I do not
No,
have.
only in absence. Now there is a dispute with your certificate.
Yes.
If the findings are not correct, you can challenge that finding.
No, I will not challenge that finding, because well, that's
So, but you had already obtained a certificate.
no. I
Which
had
had
the
not been-
now I had the certificate. If they say that in the finding that certificate at that particular point of time was
You
not
challenge
approved,
that.
then my lord,
See, when does an ossification test comes? When the other options are not available at all. You, on your own volition, you have produced the certificate.
yes.
Who is the learned judge, trial judge is not accepting. You challenge that.
No, my lord,
Can you say that, no, it's not accepted,
but
I go for
with
ossification.
utmost respect.
Ossification will come only when those
No.
certificates are not at all available.
Yes. Now, with utmost respect, I said,
there was one case of the Honorable Supreme Court which says that where also the same situation as it happened in this case, as the birth certificate was
Not accepted.
not accepted. Then the court directed
No,
that
for the larger interest and substantial justice, we can accept your submission, but we cannot just wholly ignore the law.
yes,
Madam, we would like to have your response.
or your lordship will just or your lordship, we can file a IA here also.
You
praying
filed
for the-
because we have come across
No,
cases
that procedure.
where even the age part, which was not accepted by the learned say, trial judge, was the subject matter of revision in the High Court. High Court had, in fact, interfered if the procedure adopted was not correct.
That we can do because this appeal is pending. Ultimately, when we have taken that plea, this is in respect of the accused. Will file an appeal.
One of the accused.
That will
One of the accused.
one of the
Yes,
accused.
because he has
who
not
is-
mentioned the name of
No,
the accused.
no, Bodiot
in favor
Jamal
of-
alias
yes.
Bodiot Jamal alias
You file an
Kalam.
application, we'll
That
consider
will
it.
Yes.
now.
And you
so-
can also bring on record
yes, sir.
the order which has rejected your prayer for.
And we'll give the chronology of the events, perhaps for the convenience of the
File it.
court. This is in respect of one.
But we'd like to have your response,
Yes.
madam.
Yes.
You-
Now, so far
Go
the
through it.
other
Let
accused
him
is,
refer the application.
that is in so far the accused one is concerned. So far the accused number 2, who is the father, we are praying for bail of him because prima facie it appears that there is finding the deposition of the main one injured witness and the finding of the medical report does not tally. Because he has said, well, if I for that I will press for bail.
Yes, what is your, we have filed
We
your
have filed an
objection.
objection.
Yes.
I have got objection to give your look. Let
So,
him complete.
If
his
you are
application.
pressing, you can hear it.
yes, yes. Now your lordship will see PW 8, Bakar Ali at page 94.
Just a minute. This prayer is for whom?
Is in case of Sobur Ali alias Abdus Sabur Sheikh.
Subur.
In IAS criminal number 1260 of 2024.
1263. 1263.
1260 of 2024. In criminal appeal number 434 of 2024.
Okay, just a minute. Subur Ali.
But Sobur Ali is the maternal uncle of the deceased. Oh, sorry, Bakar Ali is the maternal uncle of the deceased and the injured witness.
Subur. S-H-E-I-K. You are taking us to which
Page 94.
94
Yes, sir.
of the
Paper book of the criminal appeal number 434. Criminal appeal number 434, page number 94.
'94.
Yes.
Yes, please.
So, my lord, this is the bail is of Sobur Ali alias Abdus Sabur Sheikh, who is aged about 58 years. Now, your lordship will see the deposition. First one line your lordship may omit. When we reached near the house of Anwar Pepari, the accused Kalam, that is the juvenile in conflict with law, suddenly came there and inflicted a blow with a dagger in the abdomen of Sahidat. Accused Sabur Ali, this is the Sabur Ali is the appellant for which we are pressing for bail. Now, accused Sabur Ali inflicted a blow with a knife on the backside of the head of Saeed Ali and is sustained it. Specific allegation that he sustained, he caused the previous injury on the head. Now, your lordship will see, before I take to the contradiction and all, then your lordship will see the cross. The cross.
Page
Next page, 95.
95.
What I want to impress upon your lordship is that this incident occurred in a place where, in a public place near the masjid after the namaz, and there were a lot of independent witnesses. But only this witness, the deposition has, the statement was recorded under 161 CFC. So your lordship has to see with various cautiously as to how, to what extent it can be relied on. Your lordship will see. The masjid is at a distance of about 300 to 400 feet away from my house. There was 100 to 150 houses near the place of occurrence. The houses of Jamilan and Jamal were situated adjacent to the place of occurrence. At the time of occurrence, the shop of Rahmatullah was not there. The incident took place after the namaz. So this was a place where there were other independent, there could have been a statement of other independent witness. Now your lordship will see page 96.
96.
Yes. The third line.
Yes.
It is not a fact that I did not state before the IO that after Kalam, Sabur came to the place of occurrence. It is not a fact that I have deposed falsely that accused Kalam suddenly inflicted blow on the abdomen of Sohaid Ali with attack.
Yes.
Now your lordship will see the statement of the IO at page 111. At page, the 11th portion is at page 114.
Yes, please.
Page 114, the first line. Bakar Ali did not state me that after Kalam, Sabur came to the place of occurrence. Bakar Ali did not state me before me that Anwar Bepari inflicted him injury on the backside. Bakar Ali did not state me that Nobrul Gasud and so on. So, the Sabur came to the place of occurrence was very stiltily brought in the examination in chief. Now your lordship will see the medical report because these are the statements made by the witness and the which was contradicted by the IO. Now your lordship will see the opinion of the doctor. At page 52. No, the statement of the doctor. Just a moment, your lordship, I'm taking it to the statement of the doctor. At page 47 to postmortem, statement of the doctor. Huh? PW 5, my lord, just a moment. No, PW to 5 to mean 9. Okay. Just a moment. Doctors. Just a moment. The doctor has said that there is no injury on the scalp. That I will just point it out. It starts from page 104. Your lordship will look at page 106.
106.
10.
Yes.
During cross.
Yes.
The scalp was intact. There was no injury in the scalp.
On the back side of the head of the
The
deceased.
scalp covers the entire.
Let us see the injuries.
The
The PM
scalp.
report, PM report.
Huh?
Let us see the PM report.
Yes, yes, yes. PM report is at page 47. Because there were opinion, your lordship, opinion has always to be sustained by it's only an opinion at page 60.
No, let us see the PM report.
At page 58. the type.
58.
Yes.
Why is it not in the form?
Form is there. We have an extra form also.
Page?
Your lordship will find at page 62.
Okay,
LCR has also come, your lordship. Your lordship can see the LCR.
Wounds.
I've given the type copies, so it will be little.
Surgical bandage overhead. What is wrong? Postmortem. Don't. The CD first wound.
Yes, ma'am.
At page 59.
Yes, ma'am. I've seen that one. Inside zone of 7 centimeter into 4 centimeter into scalp deep present. So depth is
The
not
left parietal scalp located.
present over left parietal scape located 2 centimeter left to midline and 13 centimeter above superficially reach margin of which is clean cut. Whether this was caused by any weapon or whether this was caused by surgical examination, because you also will find there are lots of surgical stitch on and even in the stomach.
The
and all.
surgical, the surgery would be done for stitching, not for cutting.
But your lordship will see the
Stitch wound.
the statement in the doc and this incise wound of size 7 centimeter into 4 centimeter.
What time did the incident take place?
My lord,
What was the time of the incident?
around 8 p.m.
In the evening.
Yes.
In the evening, he says that he saw a knife on the backside. It is on the head, little bit. That's for because we are on the prima facie satisfaction.
No, we are as a different
on merits.
Yeah.
In the main and the second part, which we may just indicate that it is not a proof contradiction. The contradiction we have held in a tried to explain. There is a difference between omission and contradiction.
Yes, sir.
There is a vast difference, in fact. Omission is not saying everything in details before the police and thereafter in the doc. You may still have a case that he's trying to improve because you have not stated before this. But if you say contradiction, it has to be something which is just opposite.
No, my lord, what I am trying to.
If it would have been a proof contradiction, if in the cross-examination you have said, yes, I have not said before the police. But he denies that. He said, yes, I have said before the police. You have brought out the IO statement. No, he has not stated before me. You know how 161s are recorded. In fact, 161 is such an important part that you have to record everything relevant.
Yes.
But we know how it is recorded. It's not even signed. It's not evidence. You may still take all the advantage. Defense, yes, you are entitled to.
My lord, I can only, my job is not to prove it beyond reasonable doubt. My job as a defense counsel is only to create a doubt.
You're correct. You're correct.
I have to only create a doubt.
Now, here, the evidence of PW8 prima facie, we don't find it to be contrary to the medical evidence as well as the evidence of the IO. Yes, IO has for that it may be a good case in the on merits.
No, my lord,
But
today I am what I am saying.
on bail-
Now, if your lordship looks into the injuries, my lord. Injuries. There are 5 injuries are there.
No, we are on the first injury.
Yes.
Other injuries.
First injury, your lordship will see incise wound of size 7 centimeter into 4 centimeter in scalp.
Scalp.
That means that may be an if the depth is not indicated in an injury.
Scalp dip.
Scalp dip. Scalp dip means it has not touched the my lord, the inside of the scalp. It's just the superficial skin. That's why it says scalp dip. It has not touched the inside of the scalp. That's why it is not, the depth is not there.
Paperwork prepared.
Well, I have included everything.
Almost everything.
Yes. That's why I said that the scalp.
What have you done? What have you given? Madam, have you checked the enclosures to the memo of appeal?
Not all, your lord.
Even
Let the
the
paper will be prepared because
even the
this year has
TCR
arrived.
TCR is also
No,
there.
TCR is there. We may not waste any time because he has already given
I've given
the
I've
office.
given
We can direct the office to verify
Yes,
along with the TCR.
yes,
And if those are correct, we can go ahead with the hearing of
yes,
this
my
matter.
lord, that would be the best.
And so far as the other aspect is concerned,
Regarding suspension of.
regarding the other one,
Juvenility.
he'll file an IA in the
Yes,
meantime. We'll
correct.
consider that. We'll consider that.
take some. Monthly bonus. To me, my calendar.
Really for the completion, there has to be a case which strikes at the very outset. It cannot be a case for, we may have a good case for consideration, only for consideration, none of the workers will not know. So for the father is concerned. I go from, and at 8 p.m. saying that on the backside, because now it may be this side, that side, you know, how do you say at 8 p.m. in the night? Even front may be said back. That you cannot say that a witness is untrustworthy. How soon can you file the IA?
Well, your lordship may fix it on 28th. We'll try to file it by within this week. I'll file it by Friday. We'll give an advance copy to her also. And your lordship may fix it on 20th Monday.
Heard 3 BD Court, London Senior Counsel assisted by Madam Jane for the appellants / applicants. Also heard Miss B. Bhuya, Learned Senior Counsel in APP,
यहाँ
Assam.
में तो ट्रांसलेट का कोई बात नहीं है।
Para.
मतलब
With regard to the appellant, what is his name?
Kapoor.
Sobur Ali alias Abdus Sabur Sheikh.
No, not this one, not this one.
The other one.
Botio Chaman SK, alias Kalam Sheikh.
Botier
Is-
BOTIO.
Verify the name, huh? Verify the name from the record.
Botier Jaman Sheikh.
The London Senior Counsel has submitted that though an application on the ground of juvenility was filed before the London Trial Court.
So this court has remanded the matter to the session
Did
judge.
you
to-
file application? No, no, you did not file
Madam,
application.
Order was passed, so we just
No, no,
appeared it.
has submitted that pursuant to an order passed in this proceeding, in this appeal, to consider the issue of juvenility so far as accused so and so is concerned. A birth certificate was produced, which however has been rejected. Full stop. The Learned Senior Counsel accordingly submits that an appropriate IA would be filed so far as the said accused is concerned. Full stop. Para. Praying for bail, / suspension of sentence so far as accused Subur Ali alias Abdus Subur Sheikh is concerned. The Learned Counsel has referred to the documents which have been annexed to the memo of appeal. Full stop. Para. We have noticed that pursuant to the order of admission and calling for records, comma, the TCR, smallest, TCRS, the records have been received. Full stop. Office is directed to verify the said records along with the enclosures made in the memo of appeal. In which
All are in
case,
English only, except the FIR.
no, we'll
Ah,
verify.
yes.
In which case, the requirement to prepare a separate paper book may not be required. Requirement would not be there. Full stop. As prayed for, as prayed for list on 20th.
Monday, yes. 28th.
Can you do it?
Yes,
Today is what?
This 20,
Oh, 20th of August.
no, July.
Or 2/8. 2/8 you are saying.
Yes,
28.
2/8.
Okay. Let's not. Can you file it within a week?
Yes, but your lordship will just ask my court master to give me a photocopy of the report. I'll file it because this report was not handed over to us.
Which report?
The session judge report which was given to this court.
You have to apply for a copy.
Okay,
I mean, no, not be possible.
we'll
This
file it.
was-
We'll file
That
it
will give you some more time. 28. You will give you. You file it.
So
by-
you- on Tuesday, madam, 29.
Oh,
Your lordship will fix it at 29. We'll get the copy today.
okay. On 29th.
hearing
29th?
of the application be taken up on 29th.
Yes, yes.
No, he'll file it if it comes between. He has to file it before
No,
that.
Not the IA, your lordship, the main case,
Oh.
wherein this honorable court directed the registry to verify.
No, that is not now. That we have not indicated. We are
Right.
not causing any prejudice to him. We may not agree with him today, but we are not expressing anything. if the verification aspect is done by the registry, we can say that the appeal may be heard finally within a short date.
Right. Well, the other two appeal of that other two persons, we cannot take up the bail hearing because the TCR is with this.
No,
record.
if the verification part is done, you can press the entire appeal. Juvenility thing, we can,
But this is in respect of these two. There are other two accused whose their bail petition is pending before the learned single judge, and the learned single judge cannot direct the division bench to send the LCR from here. So your
I
lordship
think
may,
paper book would be better. It
Yes,
can
my
be
lord.
given, a copy can be given there also.
but let it the verification be done, then I think they will compare. Because otherwise it will have a wastage of time. Because everything is in English only. We have only annexed the
Then
original.
once it is verified, then you can give a copy of this entire compilation before the
Yes.
honorable single judge and you can proceed. Yes.
We are blessed.
Okay, those two are before the single judge. Okay.
Yes.
Okay. 1260 তে হব with না তিনটাতে হব তিনটাতে হব এটা জুভেনাইল টুটো আছে সেইটোতো আছে তিনটাতে হব with yes Oh. We'll just have to rise for 5 minutes. My brother has some.
17.
Yeah, please. The condition answer was that section 6 of POCSO. I have filed an IA for method bail and for suspension of sin. But it is
You are pressing the IA.
that become for hearing because
No, the
TCR
records have come.
TCR comes up.
হেৰি বনাইছে নেকি পেপাৰ বুক
Paper book has not been prepared, my lord, but except the 164 statement and the my lord FIR, everything is in the English. Only 164 statement it's FIR particular. I have attached everything in the appeal memo. I have translated that two copies of.
It is not being admitted. The person has said that you need to make the informing of the party and have you made a notice of the admission. There is no admission. From February till July, it is just lying for like this. It's not been admitted as yet. We'll admit this.
It's also better.
Yes?
It is
No, that is okay, but before, there is no requirement of issuing notice in an appeal. We admit and as a matter of admission of the appeal, notice will go, that's a different
Right.
matter. But
Actually-
where is the scope of issuing a notice in an appeal? We have to otherwise admit it also for hearing, statutory appeal, unnecessary from February to July. Okay,
last paper it was admitted.
not yet admitted, you have not checked the records. No admission, no? Is there
No.
admission? No.
Only notice has been issued. Notice also received.
It was received or what? What is the flag X? Yes, sir.
So.
In the IA, notice was not even issued. You have filed your, or notice has been issued or not? Yes, notice has been issued. Okay. Objections filed.
Objection filed, my
Yes,
lord.
yes. What about the, sir? What is this? Yes, sir. Please, flag,
There's no
sir.
action, there's no plague. yes.
Flag, sir. Yes.
Right.
Okay.
I'll put-
Okay, we'll appoint, okay. Ah. Please write, huh? Heard Sri U.J. Saikya, learned counsel for the appellant, as well as Sri R.R. Kaushik, learned APP. Full stop. Pursuant to the direction passed in the case of Deepak Nayak versus so-and-so, naam to likhi diba, huh? This court, by order dated 5/2/2025, had issued notice both in the appeal as well as the connected IA with Kurima. The report on service has been received back with the acknowledgement of the with an acknowledgement, para admit. Records have also come out.
Record the-
Records by which order? Okay, okay. No.
This is good.
Admit. Full stop. Pursuant to the last order dated 5/2/2025, the records have also been received. TCR, huh? TCR have also been received. TCRS, huh? Or S have also been received. List after 4 weeks for orders to enable the respondent number 2 to appear. Full stop. In case the respondent number 2 does not appear, this court will appoint an amicus curiae, as this matter involves the POXO.
May I pray for a date?
4 weeks we have said. List after 4 weeks. This will be in both the appeal and the IA 79. Sorry, in the meantime, the office to go ahead with the preparation of the paper book.
It will be 22nd August.
Okay, we'll have it on 22nd August. List on 4 weeks now, list on 22nd of August.
What?
18.
May it please, your lordship. This matter pertains to a mentally unsound person who's lodged in Morigaon jail. Now, we had filed a 389 application last year. Court had ordered directed that his case may be considered by the Mental Health Review Board as per the Mental Health Care Act. Nothing was happening. Subsequently, we filed this present interlocutory application. By order dated 16/6, that is the last order.
Yes,
The lordship takes paragraph 4 of that order, last
Yes.
page of the order.
yes.
My lord, matter was to be placed before the concerned Mental Health Review Board, that is in Kamrup Metro, headed by the District Judge Kamrup Metro, but no report has as of date come.
Was it placed?
My lord, the registry was direct to place, but I could not find anything in the record.
And the matter was directed to be listed today, 23/7.
My-
Is there any report?
There's nothing on report that after that, date 16th.
Report from medical has not been reached yet in the concerned section. 21/7, there is a report. 21/7, there is a note. That report has not reached, but has it been, this was transmitted or not?
I think it was transmitted.
No, it was given to madam. Did you transmit it?
Lordship, I have already sent placed the report on the last order, Lordship. Then Lordship have sent to registry to send the report.
No, no, it cannot be. After the matter was taken up by this court on the last occasion, it was
But
fixed on
all the
23rd.
reports collected from the mental Nagaon jail lot.
Madam, you have not understood. The subsequent development would be upon this order passed on the last occasion. Thereafter, matter has been listed today. Where is the occasion for you to place a report? Report will be done after verification exercise done pursuant to the last order.
Lordship, there is the last, the date that was 6 and 16, Lordship.
Yes.
According to that order, Lordship, that I was to place the report from the jail lordship. Whether the board, his report was sent to the mental board or not. That is done, Lordship. Then, Lordship, the report should be collected from district judge, whether the board has set or not. That report, Lordship,
If I may, my lord, what had happened on 17th May, the chairman of mental health review board wrote to the Morigaon jail that this person has to be taken to Morigaon Civil Hospital. He
Yes.
was taken. Some tests were done. Subsequently, that report from Morigaon Civil Hospital was communicated to the MHRB on 20th of May of this year. After that, nothing has.
No, see, Mr. Bhattacharya, the last order passed by this court had fixed today for a report from the Mental Health Review Board, Kamrup.
Yes. Yes.
Now towards that, we are asking whether do you have any information regarding any action done pursuant to the last order of this court?
I don't have.
You have to
We also do not have any information.
heard Sri D.K. Bhattacharya, learned counsel for the applicant, as well as Miss A. Begum, learned APP, Assam, Para. Sri Bhattacharya has drawn the attention of this court to the order dated 16/6/2025, passed by this court, whereby a report was called for from the Mental Health Review Board, Kamrup M, fixing today. Para. Office note dated 21/7/2025 has indicated that such report has not been received as yet. Para. Both the office as well as Miss A. Begum, learned APP, are directed to
No registry.
no, we have already, you also take instruction.
Board not. No registry.
You can write to them, they are your authorities. You can try to get some, are directed to obtain instructions on the steps taken pursuant to the last order and the status of the report which was supposed to be prepared. Para, list on when?
A copy of the order may be.
We'll give. You can take a copy will be uploaded within one hour.
Sure.
List on
2 weeks.
today is 23rd. We'll have it on 6th of August.
Right.
Let us give our to facilitate the learned APP to read the note full, to do the needful, comma. Let a copy of this order be furnished to her during the course of the day.
Sure.
Public.
Item 19.
But notice is to be issued upon respondent number 2 to the people.
IA for IA is for what?
15.
Suspension.
Item number 9.
IA is for what? Suspension or sentence or what?
Yes, sir.
Heard Miss A. Lala, learned counsel for the applicant who has filed this application under so-and-so, praying for suspension of sentence. The connected appeal has been admitted wide order date 26/2025. Para. Let notice be issued. Returnable by 4 weeks. Miss A. Begum, learned APP, accepts notice on behalf of the respondent number 1 state. Let steps be taken. This is under conviction under?
Convicted under section of
Let steps be taken for service of notice upon the respondent number 2 in the manner prescribed, which is to be routed through the office of the public prosecutor Assam. Steps within 2 working days.
But this is an appeal through legal aid, and there's a delay of 82 days in preparing this appeal. This conviction is under section 6 and 18 of the POCSO Act.
762 is for delay condonation.
Yes, sir.
Heard Sri S. Biswas, learned legal aid counsel, who has filed this application under section 5 of the Limitation Act 1963 for condonation of delay of 82 days in filing the connected appeal. The appeal has been preferred against an order dated so and so, passed by so and so. Para. Let notice be issued. Returnable by 6 weeks. Miss A. Begum, learned APP Assam, accepts notice on behalf of respondent number 1 state. Let steps be taken for service of notice upon the respondent number 2 in the manner prescribed, which is to be routed through the office of the learned PP Assam. Steps within 2 working days.
Much obliged.
Yes, how many witnesses?
My lord, we have appearing for appeal number 50.
How many witnesses?
Witness, my lord, all total witness, my lord, including that of Ayu, 13 witnesses were examined in this case. And 1 CW also examined.
Total 14.
Total
14
14
witness.
marks. CW, in fact, of not
How long are the depositions?
My lord, here, one thing there. Here, they have raised a juvenility.
Regarding which appeal?
My lord, the order was under item number 21.
Mr. Ahmed, you are for all the appellants in all the cases.
No.
You are appearing in
Hello.
which case? The case
we are appearing for appeal number 50.
50.
Nirmal Pal.
Okay. And
And-
regarding the others?
Hmm.
Who?
I appearing appeal number 94 of the 16.
9.
Shivopal, Pratapal, and Porimal.
Sivapal, you are there. Then Mr. Ahmed is there for 50. And who is for 78?
78 we are appearing.
50, 78. And 50. And who is for 50 of 17? He is? Bill, Bipul. Okay, you are there. Okay. And wait, okay. How many appeals are there?
4.
4. 94 who is there? 94, you are appearing.
Yes. We have a
Okay, 94. Then for Nirmal Pal, Mr. Ahmed is there. For Nirmal as well as Hare Krishna Pal.
Registrar Pal and Sanju Pal, man.
Sanju is along with Nirmal. There is the same
In
appeal.
criminal appeal number 2 accused appellant, man.
Okay.
50.
50 of 16.
Yes, man.
Because there is another criminal appeal 50 of 17.
Yes.
Where Madam Lala is appearing. Along with, yes. Yes.
Madam, actually, regarding three accused, Sanju Paul, Porimal Paul, and Hare Krishna Paul, they have raised question of juvenile.
There are separate appeal, man.
Then,
Pilot, we file appeal number 50 for Sanju Pal and Nirmal Pal. And 78 only for Hare Krishna Pal.
then one side order dated 29/8/83. It was directed by the to make an inquiry.
Made. Inquiry made.
Report is there. Report
Is it?
submitted the report on 16/11.
What is the report?
Report, my lord, what has happened? They failed to put the document regarding juvenile.
Yes. They failed.
They failed. So ultimately, it was done. So the case says, my lord, your people also produce the report.
Yes.
Or can read it out.
Please read it out.
My lord, one person, Porimal Paul, my lord,
Paul, Sanju Paul, and Hare Krishna Paul. 3 persons were declared juvenile.
Porimal Paul, not declared juvenile. But Porimal Paul, my lord, was said that, my lord, he is between 35 to 40 years at the time of the ossification.
And the offense was done when?
One.
How many years before?
2001. 24 years. And the question was they have to satisfy because that is there was no after 30 years. Ossification stays. Okay.
This trial was pending since 2000. The judgment is of which year? 16?
My lord, the incident happened on 24/4.
2001. Judgment came in 16. Okay.
So that court came, but that court, the age of the date of their ossification is 35 to 40 years and not for 40 to 45. Otherwise, they have failed to put in document that they are juvenile at that time. So ultimately, they acceptable or not because court the ossification days was done after all are 35.
Is there a bar in law that
But
ossification
there
test
is
can?
no bar of doing those, but there are certain positions that after 30 ossification test.
What are the this thing?
But,
No, Mr. See, these have come up for hearing, final hearing.
Yes.
Though that point it would be available to take up, to be taken up, but we are not taking up on a piecemeal basis. Those will be one of the points, one of the grounds in support of the appeal. So if they fail in that, they have other grounds on merits. If they succeed, if they urge that point, you have the right to show us that this ossification test will have no value. There are propositions.
Yes. And if they are supposed to vote, right, that vote test and
No, that will not go for all the appellants.
not all the
Three persons.
And there is one I is also has my land. Friend has filed regarding item number
313.
313.
21.
One person. It is suspension of sentence.
Okay.
Bail. But I pray because it is long pending term. So that may be hard.
No, this is for hearing.
Yes. But that I is I'm just pointing out because that I has also.
Doesn't matter. This entire appeals are, all the appeals are in the hearing column. So instead of giving our time in the IA, we'll go for the hearing. Are you ready with the matter?
Yes.
Can we proceed? How long will you take? You have to complete during the course of the day. Tomorrow, though my brother will be sitting for a short duration.
I
No,
heard
that is why we have asked, you have said 12 number of witnesses,
Yes.
14 number,
14.
14 including this CW. Then let it be before a regular bench.
Yes. That is it.
Okay.
Yes.
Okay.
Good.
Uh,
As for convenience, my lord, kindly make it 21st August.
21st August.
Yes,
Uh,
a voluminous matters, my
21st will be Thursday. Yes, what do you say? Okay. Yes, you're okay with 21st August?
Yes.
On a joint request made by the learned counsel for the parties. List these appeals for hearing on 21st of August. এই paperwork কোন তারিখ বলি?
must.
This perhaps we can do small one. How many?
6 witnesses.
Okay, I think we can be doing.
Lord. In earlier order, Lord, item 19, Lordship, they have taken step and also office has sent the notice to the respondent number 2, but we have not received the report. Lord. So today, Lordship have ordered take again fresh step. Already she have taken. Item 19.
19. What was it? 19?
What date may be fixed, Lord. Bring the
तो लिखी थी, what did we write?
Lord.
19 आपने लिया है क्या? 19 आपको नहीं लिखी? एक बार लिखी ली। कब बोले? कोई एबार वो देखा लो order to देखा लो वो को बोल किया सब। ये to hate ये juvenile और केस तो दी बोले। Yes.
Your Lordship, two appellants before your Lordship. FIR was lodged on 13/7/2016. Four persons faced trial. Out of that, 2 persons are acquitted, and these present 2 appellants are con- FIR, your Lordship will find page 4.
Conviction under
302 for that. Zero two and 34 is there. While framing charges, 449 was also there because it was the appellant illegally trespassed in the house of the deceased and took him away. That was the allegation. 49 was there, but subsequently that was the prosecution failed, so that was not convicted at that section.
Yes, please. Page 4.
Page 4.
Date.
13/7/2003. I have the honor to state that around 12:15 a.m. today, that is on 13/7/2016, as my neighbor Dipanjali Uriya, daughter of late Kamdev Uriya, died from an ailment, it was suspected that she had died as a result of my father's kumantra, injurious incantation, and around 1:30 a.m. Sri Mahesh Uriya, younger brother of late Kamdev Uriya and son of late Dhana Uriya, accompanied by a resident of Bahbari branch of Tea Estate, Assam, armed with some weapons, trespassed into our house around 1:30 a.m. and taking my father Sri Lal Bauri, 44 years, forcibly away from our house to the house of our neighbor Sri Tibu Tati. They tied my father to a post of the veranda of Sri Tibu Tati, son of late Kamdev Uriya, and then Sri Tibu Tati and Mahesh Uriya. Now this part, Lordship may kindly note, in association with the people of the village, brutally killed my father by assaulting him throughout the night with weapons like rod, hammer, spike, etc. Thereafter, they dragged the dead body of my father and threw it into the river Kakodonga. Though I was hearing the scream of my father when the miscreants were torturing him brutally, they did not allow me to go near my father. Police recovered my father's dead body from river Kakodonga this morning. Therefore, I pray to your good self to take necessary action against the Mahesh Uriya, Tibutati and other murderers and oblige. FIR also says, Lordship, that involvement of other persons. Because in the evidence, your Lordship will find that the witnesses were not declared hostile. They said a crowd of people came there and they assault. But only these two persons are convicted on the basis of circumstantial evidence. Because my submission before your Lordship would be that when circumstantial evidence, the prosecution should prove that these are the persons and no other persons are there. That has to be there. But in the present case, your Lordship will find although this present petitioner's presence was stated by the prosecution witnesses, but involvement of other persons, that crowd, that has not been negated by the prosecution. And charge framing, your Lordship will find page 7.
No, this will depend on what the investigation found out against whom the charges were framed, or rather against whom the charge sheet was filed. See, this is the version in the FIR. FIR is not even an evidence.
But this corroborates the evidence. The evidence.
We'll have to see what is the IO's evidence. What evidence did he found prima facie against the persons charged? And out of those 4, 2 have already also been acquitted by the same judgment. You have already informed us. Let us proceed.
Lord. And in the charge framing head, Lordship may kindly see page 7. Just for a moment, Lordship will see that 4 persons were there in the while framing charges. And what are the charges? Lordship will see. Firstly, that on so at about 1:30 a.m. at village so T Basbari line under PS Pulivor in the district of Jurhat, in furtherance of your common intention along with others. And similarly, in secondly, also your Lordship will find in furtherance of your common intention along with others. Evidence starts from page 10, PW1. That you'll page 10.
Yes.
I am the informant in this case. I know the accused persons. The incident took place some 2 years back. On the day of the occurrence, I was at Naharoni. At night, that day, my mother told me that Mohesh Puria had called my father away from our house. Thereafter, my father was taken to Tribhu Uria's house. Around 6 a.m., I arrived home. My mother was crying and she told me that my father was killed and thrown into river Kakodonga. When the police brought the dead body of my father to our house, I saw injuries on his entire body and his frontal teeth were missing. Thereafter, I lodged an Ajahar with the PS. Exhibit 1 is the Ajahar and Exhibit 11 is my signature therein. Police held inquest on the dead body and I put my signature on the inquest report. Exhibit 2 is the inquest report and Exhibit 21 is my signature thereon. Cross. I do not know what was written in the Ajahar. I put my signature as I was asked to do so. I do not know in what condition my father died. Accused Mohesh Surya is not our relative. He is our neighbor. Occasionally, my father accompanied him on outing. So when he took him along with the disease was taken by that Mohesh Surya, that was not an isolated incident. Earlier also they used to go. It is not a fact that my mother did not tell me that my father had been hacked and thrown into the river. But she did not tell me who had killed him. The police questioned me before recovery of the dead body. It is a fact that my father used to consume liquor. It is not a fact that my father had an illness of shivering and that the accused persons were not involved in my father's murder. Now, PW2. The informant is my elder brother. I know the accused persons. They hail from our Basti. This is Lal Bauri was my father. The incident took place about 2 years ago. On the day of the occurrence, when I was at home, a girl by the name of Dipanjali Uriya of our neighborhood died. When I was at home, my father went to see the dead body of Dipanjali. Orang. After a while, Bapu Uriya came to our house and said that my father was kept tight and he asked us not to come out of the house. On the following morning, I found my father's dead body. At this stage, prosecution witness is declared hostile at the prayer of prosecution side. It is not a fact that I stated to police that on 13/7/2016, Mohesh Orang, accompanied by Pitho Tanti, came to our house. And taking my father away, they assaulted him in the house of the deceased girl. That I heard the scream of my father and that I could not recognize the people as it was dark and large number of people were there. So prosecution case is also that large number of people were there. It is not a fact that I have adduced false evidence in favor of the accused. Cross. I do not know how my father passed away. The things I have deposed in the court today are true. I have not deposed the false out of the fear of anybody. Now, PW3, page 14. The informant is my son. The accused persons are our neighbors. One day, some 3 years ago, accused Mohesh Bauri came to our house and took my
This is the
husband,
wife of the deceased.
wife of that.
Yes, please.
Mohesh Bauri came to our house and took my husband Lal Bauri to Tibutanti's house. So here just I'm pausing for a moment, Lordship. Here your Lordship will not find that any force or anything was used while taking him to that part. So even if we admit that he was taken to that house, there was no motive on that part from the circumstance what it appears. Lord. My husband was assaulted there. By whom? That is not stated. Although we went there to see him, we were not allowed to do so. Papu Uriya forbade us from seeing my husband because the accused might assault us. So Papu Uriya, not an accused, he was the witness, but he died, so he could not be accused. My husband was assaulted from 12 midnight. He was assaulted in the house of Tibu Tanti by tying him up. Later, police recovered the dead body of my husband from river Kakodonga. They assaulted my husband, alleging that my husband was a Dangoni, quack. Tibutati's daughter Dipanjali had died before this incident. So here your lordship will find they assaulted. They means who? That is not clear. Because 4 persons face trial. Other persons are there. Crowd is there. So this evidence is not clear who were those persons who assaulted. Page 15, third line, lordship, that they assaulted my husband, alleging that my husband was a Dangoni. Correct.
You cannot read in this statement in isolation. Read the second sentence in the first line itself. Accused persons are my neighbors.
Yes, accused person.
This has to be has to be read in the context of the accused person.
Yes, that is what I am submitting to your lordship, that 4 persons face trial. So what she meant that all 4 were there.
All 4 were there.
But those 2 are, out of them, 2 are acquitted. That is what I was pointing
No,
out.
we'll see on what grounds they have been acquitted.
Lord. Cross. I was inside my home. I did not come out of the house. Prior to the incident, my husband had a good relationship with Mohesh. Prior to the incident, my husband had a good relationship with the accused persons too. I was not aware who had tied my husband up and assaulted him since I was at my home. So that part he has not been beating part. At the time of occurrence, the backside of my house was submerged. The entire tea estate was flooded. The entire area from my house to the river was submerged. It is not a fact that I have stated falsely that the accused persons had assaulted my husband. I do not know how many people gathered at night. It is not a fact that out of suspicion I have stated that the accused persons were involved in this case. My husband used to consume liquor at night. I do not know if he drank alcohol during daytime as I had to go for work. At night, on the day of the occurrence, my husband was sleeping after consuming alcohol worth ₹10. Occasionally, I suffered from a disease that caused shivering in my body. It is not a fact that the accused persons did not assault my husband. Now, medical, your lordship will find that page 17. So at this stage, I am not disputing that those injuries, lordship. But injuries, your lordship will find page 18. Opinion, your lordship will find page 19. As to the cause of death, death was due to coma as a result of head injury. All injuries were antemortem caused by blunt weapon, which was homicidal in nature. So page 21, he was the PDP secretary at that point of time.
Chest, abdomen, shoulder,
Yes, 21 is who's 21?
Uh,
PW5?
VDP secretary, PW5. I know the complainant Pavan Bauri of the present case. I also know accused persons Mohesh Uriya, Rajiv Bauri, Ashok Tanti, and Tibu Tanti. I am VDP secretary of Barbary Tea Estate. I also know the deceased Lal Bauri. The incident took place about 4 years back. I came to know about the incident in the morning. On the day prior to the incident at about 7:30 p.m., I, along with Tani, visited the house of Tibu Tanti to inquire about the health of his sister who was suffering from tuberculosis. Upon reaching there, pharmacist of Bahbari Tea said Tani, who had accompanied me, declared her dead. The next morning, Secretary of the Tea State Mazdur Sangha, Bapu Uriya, since deceased, informed me that a crowd had killed Lal Bauri. So this part I was stressing lot. A crowd had killed Lal Bauri and asked me to come to the place of occurrence. However, considering the seriousness of the incident, instead of visiting the place of occurrence, I called the Pulibor police station and informed them about the incident. Police came to investigate the case. The inquest of the dead body of deceased Lal Bauri was conducted in the presence of executive magistrate, and I signed the inquest report as an inquest witness. Exhibit 2 is the inquest report and Exhibit 2 is my signature. Cross-examination on behalf of accused. Papuria informed me that crowd from the garden was physically assaulting Lal Bauri. He did not tell me that Lal Bauri was dead. I do not know if Lal Bauri was tied up during night. I have heard that Lal Bauri was thrown into Takodonga River, as a result of which he died. Babu Uriya did not tell me that the accused persons were involved in the physical assault or killing of Lal Bauri. So my submission to Lordship is that from the evidences, what I find that Bapu Uriya was the person who had seen the incident. He restrained the PW3. He informed PW5. And that Bapu Uriya informed the PW5 that a crowd had assaulted the deceased. And this witness is not declared hostile. So whatever he has stated, Lordship, that will be binding on the prosecution. PW6 is the investigating officer, page 23. On 13/7/2016, I was posted at Pulibor PS as attached officer. On that day, one Pavan Bauri lodged an Ajahar and it was registered as Pulibor PS case number 197 of 2016 under section 302 IPC. The then OC Pulibor PS, Mr. Rishikesh Hazarika, entrusted me to investigate the case. Accordingly, I took up the investigation, recorded the statements of informant as well as accused. I visited the place of occurrence, recorded the statement of witnesses, and prepared a rough sketch map of the place of occurrence. Exhibit P4, P6 is the sketch map, and Exhibit P41 is my signature. I caused the arrest of accused and he was sent to judicial custody. Before I entrusted for investigation, ASI Sharif Hussain recovered the dead body and inquest was done over it in presence of the executive magistrate. Exhibit P23 is the signature of ASI Sharif Hussain, which I know.
The dead body was sent for postmortem, as revealed from CD. Afterwards, I caused arrest of accused Tanti, Rajiv Bauri, and Tibu Tanti in connection with this case and sent to judicial custody. Later, I collected the postmortem report, and after completing my investigation, I laid down charge sheet as against the accused person. Exhibit P5 PW6 is the charge sheet, and Exhibit P51 is my signature. It is a fact that PW2 Raja Bauri stated before me that on 13/7/2016, accused Mohesh Surya came along with Tibu, visited his house and took away his father and beat him, and that he heard the cries of his father. Cross-examination. It is not a fact that PW2 Raja Bauri did not state before me that on 13/7/2016, accused Mohesh Surya came along with Tibu, visited his house and took away his father and beat him, and that he heard the cries of his father. I do not know from where the dead body was recovered, as it was recovered by ASI Sharif Hussain. It is not a fact that, except the family members of the deceased, no other person's statement was recorded as witness. Because it is admitted fact that there was crowd. It is not a fact that there was no proper investigation. It is not a fact that I laid down the charge sheet against the accused person without any basis. So these are the evidence of it. Sketch map, your lordship will find page 82. But in the sketch map subject to correction, what my learned senior friend says, I do not find the house of Kibu Tatip. The sketch map, page 80,
82.
80.
মন কৰি দিয়া পিছত দিবলৈ 15 মিনিট পিছত দিব 82
So from the evidence, it appears that house of the Tibutati was the place of occurrence, and body was recovered from the river. So that river, that part cannot be the pure. So how far that is, that part is also not there.
In the index part, if you find against A, place of occurrence,
PO,
flood, within bracket, body floating.
Body float. The place where the body was found, because in the evidence it is said it was recovered from Kakodonga River. Body was recovered.
No, see, Kakodonga is adjacent to the paddy field and there was flood.
Yes.
So the body was found floating in the paddy field.
Yes.
Flooded area.
Flooded area, not the
Yes.
house.
Not the house. That was not the. They said that they have thrown the body in the Kakodonga River, and since at the time of flood, they say that body was found floating in the particular place. See flood, Barbary. There you go.
The house is where his house is situated. That is not there.
Yeah, perhaps that has not been. That is not there because in the context of the place of occurrence, they have treated the place of occurrence to be the place from where the body was recovered. You may be correct. There could have been two sketch maps. That this is the.
That was probably.
In many of the cases, we find more than one sketch maps, and it is required at times.
Yeah, because
the assault is done somewhere, body found
yes,
somewhere else.
In that those cases, to sketch maps are. Now, the circumstances which the learned trial court relied, that your lordship will find page 58 of the paper book, paragraph 46.
Yes.
So first was that that the sister of Tibutati died just prior to taking to Lal Bauri to Tibutati's house by Mahesuriya, suspecting Lal Bauri to be a witch, Daini, and suspecting him to be behind Tibutati's sister's death. So that probably is not the proof circumstance. And the PW5 says that the sister of Tibutati died in the evening, 7 to 7:30. That incident occurred at night. What?
So there is a chronology. Five is how is the deposition of five inconsistent?
No, because Lordship, from the evidence it is not clear. Because of that purpose, he was taken to the house of Tibutat by Mohesh. That is not true. Because he was not armed with any weapon, no force was used. Simply he went there and he was taken. That part.
What does the PW1 says? PW1 is perhaps the
He heard from PW3.
no, the PW1 is the informant.
He is the informant. He heard from his mother, that is PW3, then he lost that.
Okay.
And then your lordship will find that Mahesuriya called and forcibly took Lal Bauri. So forcibly what? That subject to question I have not found in the evidence. The forcibly part. On the night of 13/7/2016. Then your lordship will find that accused Mahesuriya took Lal Bauri to Tibutati's house. That Lal Bauri was beaten at Tibutati's house. By whom? That is not there. The accused persons, Mahesuriya and Tibutati, were the last persons to have seen the deceased. So they are not the last person. The crowd was there. The prosecution could have examined persons from the crowd. The deceased Tibutati's dead body was recovered from Kakodonga River in the next morning. That after recovery of the dead body of Lal Bauri from Kakodonga River and the fact that the dead body bore multiple injuries marked as identified PW1, which was further corroborated by the MO PW4 on the A side. Now, 8. No explanation was offered by the accused persons Mahesuriya and Tibutati as to when Lal Bauri left Tibutati's house. So that pardon will come when only that incident occurred in secrecy. That incident, if the present incident had not occurred in the secrecy, Lord, the crowd was there, large number of people were there. So it is burden of the prosecution. You examine a person from the crowd and say that this incident has occurred. They cannot receive the burden when a crowd is there, that he has not explained anything. If it is occurred in a secrecy within a four corners of a house, then I can understand that 106 will come. But it is
the narration in the Jahar by PW1 regarding use of force while trying to take the father of the informant to the place of occurrence where he was allegedly assaulted. How is it proved? Who has proved that?
No one has proved, because he lost the case from the after hearing from PW.
No, that is the version he got his from the information from his mother.
Mother did not say anything about.
No, as a substantive piece of evidence. Where is the evidence regarding use of force?
In the evidence, I have not found. Even PW3 also is silent regarding force.
No, see, the informant is one of the son who at that relevant evening was at Naharlagun.
That is
he came home in the next morning at 6 a.m. By the time the incident was already over. And but he has a brother who had also deposed. And brother says that he was at the house, in the house. What does the brother, let us again go back to the brother.
PW2, page
PW2.
12. He was declared hostile. And in the hostile part, which the prosecution wants to place Lordship, that Lordship will find page 13. Even if we accept that part also, then who is Pitu Tanti? That is not who accompanied Maheshwar. Who is that Pitu Tanti who came to the house of his father?
No, that apart, he has denied this suggestion.
It.
So it is not a proof contradiction.
So just I'm placing to Lordship that prosecution wants to say that Mahesh.
No, it's not proved. That is the IU statement. Contradiction to be proof contradiction, he has to admit in the cross-examination.
And that part has to
In
be
the
agreed.
cross-examination, he has said that it is not a fact that I stated before the police.
He denied, my lord.
Ah, yes, there is a
This is not-
contradiction. It's not a proof contradiction.
Lordship, but he denied because he was declared hostile, Lordship. But it was proved by Lordship from his statement by the IO concerned that it was stated before him. He heard the scream. It was stated before him, whatever he has. Since he has denied whatever he stated before the IO, he was declared hostile.
If IO wants to prove that contradiction, Lordship, then IO has to mark as exhibit that portion where he has Lordship stated before him. That exhibit is not marked, that part. That statement has to be exhibit. That part.
No, this, if you read 13, it almost appears to be verbatim. That part has been taken care of. See, if you read the entire thing, it is almost in semicolon. That I heard the scream of my father, and that I could not recognize the people. It was dark, large number. So that case, the proposition has been, I think, more or less taken care of. What is that matter? Shukla or Mishra, what was it?
VK,
Vike,
and Tahsildar 6 case.
Vike, yes. Vike Mishra.
And regarding that other co-accused person's Lordship, here only stated that while taking that person's deceased from the house, those persons' name was not stated, therefore they are. But in the evidence part, I have shown to Lordship that the PW3 used the word they assault, not specific that these two appellants. And against them, no appeal against acquittal is filed by the state. That paragraph 57, your Lordship.
Let us read the position of the wife of the deceased at page 14.
Page 14. The informant is my son. The accused persons are our neighbors. So accused person. One day, some 3 years ago, accused Mahesh Bauri came to our house and took my husband Lal Bauri to Tibutanti's house. My husband was assaulted there. So by whom? That is not there. Although we went there to see him, we were not allowed to do so.
Yes.
Bapu Uriya forbade us from seeing my husband. So Bapu Uriya forbade her. It is not the crowd or the accused person. Bapu Uriya forbade us from seeing my husband because the accused might assault us. My husband was assaulted from 12 midnight. He was assaulted in the house of Tibu
When
Tanti.
did this Bapu pass away, expire?
He was charged witness, but probably during trial he died.
Okay.
He was
a named witness.
Yes.
Before he could deduce his evidence, he passed away.
passed.
Okay. He was not one of the accused.
No. Later, police recovered the dead body of my husband from river Kakodonga. They assaulted my husband, alleging that my husband was a Dangoni quack. So here also the word used is they. And in cross fourth line, your lordship will find, I was not aware who had tied my husband up and assaulted him since I was at my home. So that forwarding part also is down.
Yes.
That is not a case. Lord. The present case, lordship, it is not as these circumstances do not pinpointly point towards the guilt of the accused person. Because here involvement of other persons cannot be ruled out. Merely because he lordship that Mahesh Surya was has taken the deceased to the house of Tibu Tati lordship. That part cannot be said lordship that they are involved in the offense because prior to that they were not armed with any weapons or they had not used any force to hit. And it is admitted part that a crowd was there. That PW5 says a presence of crowd who assaulted, and he was not declared hostile. And unless he is declared hostile, his evidence is binding on the prosecution. And 106 cannot be lordship said to be applicable in the present case because lordship that it has not occurred in a secrecy that that the present appellants were only know about the incident. There was a crowd who also know about the incident. So prosecution cannot be relieved from their burden of proving their case.
Let us read 106.
Sure.
What are the wordings? It is no doubt used in a closed context where only the appellant, only the accused and the deceased.
Lord.
What are the wordings?
Burden of proving fact, especially within knowledge. When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. So
It is the
not
special knowledge.
special. So it is not the they are not the only person who are present there. They could have examined other persons from that crowd, Lord. They have not
No, the
examined.
expression is a special knowledge, not knowledge to the exclusion of others. Though it is used in the context which you are trying to impress,
Sure.
but the expression is special knowledge.
Special knowledge. That
But non-examining other witnesses, will it be a point of argument?
because Lordship, it is the burden of the prosecution
No,
to
if we
establish
are
this case.
satisfied that the quality of the witnesses
Lord.
which have been examined by the prosecution would be enough to come to a conclusion of guilt, simply by non-examining other witnesses, will it be a point of argument?
Because Lordship, here your Lordship will find that who assaulted, that part is not there. Because
You want to say that the existing witness evidence is not enough
yeah,
to
that
come to a conclusion of
conclusion
guilt?
that these are the persons who assaulted the victim.
Yes. Okay. Anything else?
That is my
Yes, madam.
Lordship, in this case, the prime witness would be PW3. Lordship, the wife of the victim, your Lordship.
This is.
This is wife of the deceased, madam. She has categorically deposed before the learned court below that accused Mahesh Bauri, my lord, he came to their house and took her husband to Tipu Talki's house. And your lordship, the intention and the motive is, your lordship, although it's a circumstantial evidence is required, lordship, in the FIR itself has been stated because she is there is a she's engaged with all this lordship quack.
He, not
He,
she.
my lord, the victim. my
This
lord.
is,
Yes, my lord. And as the daughter of the accused Tiputati died, your lordship, for that reason, Mahesh called this victim, the deceased, from
how
his
is how is Mahesh connected to the family of the girl who had passed away? Is there any evidence?
It hasn't come up on
There is
evidence.
no evidence. We have not found any connection. He may be a family friend, he may be a relative,
Maybe, my lord.
but it has not come out.
My lord. Please
But
take-
wife,
Yeah,
what we were just trying to get it from you.
my lord.
See, in the FIR, there was narration that they trespassed with arms and forcefully took the father.
My lord.
The FIR was obviously based on hearsay.
Yes.
From information which he has received,
Right.
because in his deposition as PW1, he clearly says that he was not even present on that day in that relevant place. He was at Nahalagun.
Right.
He came on the morning. So he got some information. This information he could have got either from his brother, PW2, or his
from
mother,
his mother.
PW3.
My,
Brother has turned hostile.
my lord.
Even hostile witness, we can take those
Take it to-
part which comes to the aid of the prosecution,
Right.
but we don't find any of this indication that somebody came with arms, took him away by force. Mother says, yes,
Right.
Mahesh came and
My
took
lord.
him.
My
But what Mr. Ahmed is trying to, so far as mother is concerned,
My lord.
he's also emphasizing on one part. Uh,
Lord,
the
accused
cross-examination.
persons are neighbors.
The cross-examination, prior to the incident, my husband had a good relationship with Mahesh. Prior to the incident, my husband had good relationship with the accused person.
person.
I am not aware.
Lordship, as what I have understood from the submission made by my learned friend, the accused person's lordship, these witnesses are not referring to whoever is before the court. The villagers cannot be termed as the accused persons. The persons who has been charged, my lord, they can. Yes, my lord.
On that we are not. We
Lordship,
we are not. We are clear. We are
My
referring to the accused person.
My lord.
But what he's saying that prior to the incident, husband had got a relationship with the accused persons.
Yes, my lord. Accused persons, including Triputanti.
Yes.
As his daughter died, lordship, that for that reason only, maybe, your lordship, because he was engaged with quackery, your lordship. And as she died, they might have under the impression that for his action, the victim, the daughter of this accused person died. He put on. And your lordship, involvement of Mahesh, your lordship may take into account the last in theory. Because the 215...
Okay, we'll come back. We'll come back. Maybe 5-10 minutes here and there. But maybe 2-5. But you be here by 2.
Unavailable warrant of arrest and fix the matter on 6th. Can it be on any other day other than 6th? Either on 5th or 7th?
I think it's signed already. Is it signed? Signed, no?
No, your presence may not be required. It's for the execution of non-bailable warrant. You have any of your colleagues there? At best, if everything goes on well, appearance would be there and bail would be granted. Which date otherwise suits you, in case we can?
Lordship, we have requested the stenographers, like
No, which date suits you?
or any date other than 6th.
Let's see. Let us see. Yes.
Lordship, what I was submitting, your lordship, last in theory may be applicable, my lord, in case of Mahesh, my lord.
Yes.
In case of Mahesh, because on...
You are trying to invoke the last in theory.
Yes. At around 12:15 a.m., he was taken as per allegation. He was taken and lordship, as per the inquest report, 4 a.m. dead body was recovered.
12?
4 a.m.
12:15?
a.m.
He was taken when?
taken from home.
12:15,
Yes,
midnight.
yes. And dead body, as per the inquest report, was recovered at 4 a.m. So time gap, that is only 4 hours.
4 a.m. they could recover the body from the water.
As per the inquest report.
How
Lordship,
is it
may-
possible? How will it remain floating? Sketch map says that the body was found floating.
Yes, your Lord.
It can
Inquest
4 hours,
report-
the body will not float. There may be some discrepancy in
Maybe.
in describing.
71.
It may not be floating, it may be lying, it might have been
Lordship,
lying, but
my
we
lord.
do not know. Where do you get the time when the body was recovered? Inquest.
4 a.m. Yes. Around 4 a.m. today, that is on 13/7, the dead body was recovered with the help of NDRF.
Divers.
Yes, NDRF dive.
What is this date then? What is this time in page 71?
There's PD and female, which was not executed.
No, 71, page 71, inquest.
Yes. In
First, serial number 3.
serial number 3, recovered from Kakodonga River.
That body
13/7.
found, trace, date, 13/7, time 10:25. It may not be 4 a.m. 4 a.m. in the morning, when it is dark almost. Which date?
July may not be that.
Probably that is the time of inquest, Lordship, at serial number 3.
Yes.
And dead body was found by the morning.
No, dead body found traced.
No, because page 74, column number 14 says, time and date of inquest is 10:40 p.m. The inquest was done after lodging of the
40. Then again, serial number 3, what does it mean?
Serial-
To 4 a.m. As per a statement of the witness, the witness suspected that the girl from village were carried procedures, so they apprehended him and taking him away, they assaulted and dragged his body into it 4 a.m. today. Okay.
And regarding motive part, your lordship, why he was killed? Because daughter of this one, accused number 1, Ibutati, she died, my lord. And there, maybe it was India minded because of quackery, she died by committed by the deceased first, practiced by the deceased first. Although in the sketch map, the residence is not shown, but he was their lordship. It has come upon evidence that he was their lordship neighbor, my Iputat. They used to reside.
Who has said? was anything recovered? Because we find not directly in the evidence, in the FIR,
My lord,
there are allegations of use of hammer, spikes,
nothing has been.
no recovery as such.
Lordship, as per evidence of PW1, cross-examination, Mahesh is our neighbor. Accused Mahesh is not our relative, he is our neighbor. Occasionally, my father accompanied him on outing. It is not a fact that my mother did not tell me that my father had been hacked and thrown into a river.
So you say that last seen theory would apply in this case because of
case
the
of Mahesh.
proximity of time.
My lord,
From the time he was taken away from the house and from the time the body was recovered,
This
it
thought.
was last seen with this particular
My lord,
accused persons. Number two, there is a motive
my lord,
because it is under the influence of the deceased that the daughter of the accused number one had passed away.
my lord.
And so they wanted to seek revenge or
My
anything
lord.
of the sort. Okay.
So, Lordship, the accused person or an explanation, my lord. Under
Well,
106.
Mr. Ahmed is emphasizing on the fact that the allegations have been made generally against all the public. And this is fortified by the fact that 4 were charged, same evidence, 2 have been acquitted
My lord,
and 2 have been
my
convicted.
lord.
So if there can be an acquittal on the same set of evidence,
My lordship, but in
what
case
is the
Mahesh,
so the question which we put ultimately based on this is what is so incriminating against these 2
yes,
present appellants, which is there and which is exceptional to those 2 which have been acquitted,
my lord,
who have been acquitted.
lordship.
Yes.
In case of Mahesh, your lordship, last in period be applicable. Lordship and the other person, as his daughter died, Tibu, as the incident had been taken place in his house, my lord. Although it was not shown in the sketch map, the place of occurrence, my lord. PW2, although he was declared hostile, your lordship, he deposed that. Lordship, may I take your lordship to the evidence of PW2? The informant is my elder brother. I know the accused person. They hail from our basti. This is Lal Bari, was my father. The incident took place about 2 years ago on the day of occurrence when I was at home. A girl by the name of Dipanjali Oria of our neighborhood died. When I was at home, my father went to see the dead body of Dipanjali Orang. After a while, Papu Oria came to our house and said that my father was kept died, and he asked us not to come out of the house. On the following morning, I found my father's dead body. Then he was declared hostile. It is not a fact that I stated to police that on 13/7/16, Mahesh Orang, accompanied by Fito Tanti, came to our house and taking my father away, they assaulted him in the house of this girl. Then I had heard the scream of my father and then I could not recognize the people. And it was dark and large number of people were there. It is not a fact that I have adduced false evidence. Then I do not know how my father passed away. The things I have deposed in the court today are true. I have not deposed or false out of the fear of anybody. Then may I take your lordship to the evidence of IO TW6, my lord? Cross-examination part of page 24. It is not a fact that PW2 Raja Pauri did not state before me that on 13/7, accused Mahesh Surya came along with Tipu, visited his house and took away his father and beat him, and that he heard the cries of his father. So he was very much present there, although he was declared hostile. He stated before the police. He heard the scream which was inside the house of accused lordship Tipu.
What is the distance between the house of the accused and the house of the deceased? Accused means the house of the accused number 2.
Mahesh.
No.
Tibu.
Tibu.
Lordship, nothing has come up on everything.
Because son of the deceased,
My lord.
he claims that he could hear the shout.
My lord.
So that means the distance could not have been much.
My lord.
Trace map is silent regarding the houses.
Even PW2 says PW3 says, my husband was assaulted from 12 midnight and he was assaulted in the house of Tan. You put up your tin key by tying him up.
Let us see the 313.
Total denial of.
Okay. Anything else, madam?
Not sure. I'm trying to figure out whether any address is given, whether they decide the type of how far it was. And no explanation from their side.
106.
And there is no like, why would PW3 would implicate this person, Mohesh, and there was no enmity as it has come up on evidence. No previous enmity was there.
This will be a double-edged sword. If there is no previous enmity, why should they kill?
No. Regarding my lord, why would any innocent person would be implicated unless something had happened?
So that is what we have
My
said.
lord.
It will have double edge.
My lord,
They
lordship.
can also take the advantage. No enmity. Why should they kill?
Yes, enmity has arisen because.
No, your implication
My lord.
comes as a retaliation.
My lord.
Somebody, I think that he has killed, so I make an allegation. But the first primary question would be, why a person having good relation would kill somebody?
No, because of the reason. This is practice in witchcraft. This
No,
quackery, as a
those-
result of which she died.
those are there, but
No, double as the previous. So I leave it to your lordship to balance, my lord. The lordship is.
close this. Okay, we'll close this.
Just one thing, Lordship, I'm pointing out that my learned senior friend has mostly relied on the last in theory. So whether last in theory will come in the present case or not, Lordship, kindly for a moment, page 22.
2-2.
Yes. Cross-examination of PW5.
Yes.
Apuria informed me that crowd from the garden was physically assaulting Lalbagh. So the deceased was in custody of the crowd. Now last two line, Lordship may kindly see. Babu Uriya did not tell me that the accused persons were involved in the physical assault or killing of Lalbagh. So whether I was these two persons were part of that crowd or not, they have to first establish that part. They failed to do so. That these present two appellants were part of that crowd. Only then lasting theory will come. Because after what prosecution says that Mohesh Surya took the disease. After that, he was seen in the custody of crowd, not in the custody of the present two appellants.
Lordship, this Bapu, Nipen Tassa, he is a hearsay witness.
And
He was
he-
not even at the place of occurrence. He heard everything from Bapu Uriya, who is not before this honorable court, who has not deposed anything. Because he subsequently died.
Regarding that, also just on my submission, also, I am relying on 4 citations, Lordship, that I have given the copies, Lordship. So first one is, Lordship, that to air 2025 Supreme Court, that is Lordship Padman Bihar versus State of Orissa. I am relying on paragraph 20 and 21.
On regarding what?
Regarding last in paragraph 20 and 21. In these two paragraphs, various judgments of Honorable Apex Court reiterated, and it was held that only that last in theory itself is not sufficient to convict a person. That Kanhaiya case was also discussed in paragraph 20. Yes.
Yes.
The next judgment is your Lordship judgment that Moni Kakoti. He has said.
Which paragraph?
Paragraph 39 and 41. On circumstantial evidence, Lordship discussed here about British and others. Just I am reading one paragraph. Your Lordship. Paragraph 39, Lordship, that British paragraph
No,
quoted.
that is not required. 39 is okay then.
That it should exclude every other hypothesis. That part.
39 and
39 and 41. That your Lordship relied on Sujit Biswa's case, Honorable Apex Court. That,
suspicion.
regarding
Okay.
next judgment, Lordship, that Raja Ram versus State of Rajasthan.
Paragraph
Paragraph 9.
on,
Lordship, that prosecution is bound by its own witnesses, Lordship, unless it is declared forthright. And last one, Lordship, that Rina Hazarika judgment, Lordship, on 106 of evidence.
para,
Here, Lordship, paragraph 3, 4, and 8. 3 and 4 regarding facts of that case, Lordship, which is, I think, Lordship, in my case, is better than that case. In that case, wife was there along with the husband, and husband was found in injury with injuries. And even then, Lordship, that prosecution failed to prove any other material. So, Honorable Supreme Court said that 106 cannot be. These are the subjects. And they are in custody from the date of the death.
yeah, man. Beware. Reserved. Okay, we have reserved the judgment.
Oblige.
May I please, Your Lordship? This appeal is preferred against the judgment and order, my lord, on the on the plea of the guilty of the accused defendant. Under section 302 IPC, my lord. He was imprisoned, convicted to suffer rigorous imprisonment.
Madam, how long will you take?
Yes, my lord.
How long will you take? How long will you take in the arguments?
No, very small argument. 10 minutes, this is at 10 feet.
And he has pleaded guilty or what?
My lord, in this appeal, my lord, accused himself pleaded guilty, my lord. Pleaded guilty.
I pleaded guilty where? In 313?
Under section 302 IPC, my
No,
lord.
no. Pleaded guilty where? In the examination of 313?
Yes, my lord. Please, 313.
313 statement.
313 statement, my- under section 313.
He pleaded guilty.
Yes, my lord. Statement of the accused person.
Let us see. Where is 313?
I am going through the paper book, my lord. Paper book in page number 30. Page number 30, lordship. 30 to 30. Question number 1.
No.
PW1. He answered against the question number 1. A quarrel took place. I hacked her on her neck with a pruning knife, so she sustained the injury. I committed a mistake. And in response of question number 2, he answered, she might have died because of that injury. I caused injury to her.
Was there any confessional statement, madam? No. Confession is also there? No.
I don't put the statement. That is there.
No, no, that is 313. What about a confession statement? Is there any confession statement? No confession statement.
Statement. It is page number 89.
That is Nabojyoti Mura. What is the name of the? He's Sanjay Mura.
Nabojyoti,
89 is Nabojyoti.
Nabojyoti, he is the son of the appellant accused.
No, we are asking about a confession by the appellant. Did he make a confessional statement? We don't think so.
It is not actually, lordship, I have done one Sajan Mura. This Sanjay Mura. So when my landed friend is submitting, I am embarrassing. I'm not.
But Mura is there, okay, you can still argue.
Sajan Mura.
You don't have Sanjay Mura.
Now I got it.
Around 20 pages of evidence. Can we do it? Because 313 is also there, where he is admitted. So we'll just see whether the corroborating materials are there in the evidence, then we can just dismiss it. Yes, madam, we will be slightly fast because there may be shortage of time. If you can complete, we will have it today itself. Can you complete?
Yes, my lord, I cannot tell 161 statement is not found by the paper.
161, we are not on 161. We are on the confessional statement of the accused. It's not there. We have checked. You just narrate your matter case. How did it start?
going to the paper book. Page 30, page number 30.
Yes, please start.
My lord, in page form for recording evidence of the accused, in page number 38, examination of the accused person. Examination of accused person under section 235, subsection 2 of CRPC.
No, this is a sentence hearing.
Yes,
We are not on sentence. Start the case. Start from the beginning. How did it start? What had happened? Just narrate the events.
My lord, the
Begin-
case is that against the accused person is that on one in page number 4, my lord, the informant lodged an Azahar before the OC of Bokakhat police station, stating inter alia that subject killing of my younger sister by my brother-in-law by hacking on her neck with dao. Sir, humble submission is that the marriage of my younger sister was solemnized with Sri Sanjay Mura, son of late Vishnu Munda, a resident of Borveta village under sub-jurisdiction of Bokakhat PS. After the marriage, they were leading their conjugal life together for a period of 8 years. So far as I have learned, 2 days ago, a quarrel took place between them and he beat my younger sister. As a result, my younger sister took shelter in my house. She told me that she had been beaten and thereafter I kept her in my house. At about 4 p.m. today, when I was not at home, my brother-in-law, Sanjay Mura, came to my house and after hacking at the neck of my younger sister with a dao, he left for his home. When I came home and saw my sister bleeding, I inquired about the incident and then I learned about the same. Subsequently, we admitted my younger sister in Bokakhat Civil Hospital by taking her there in a 108 ambulance, but the doctor at the hospital declared my younger sister dead. Received and registered the case Bokakhat case 86 of 2022 under section 302 IPC, and the police has investigated that case. Thereafter, during the investigation, police IO examined 16 numbers of 11 numbers of PWs, my lord.
What is the name of the deceased in this FIR?
He was Suman Munda, 30 years old. And the case was started, then trial was started, and before the learned sessions, my lord, and during the trial, 11 numbers of prosecution witnesses were examined and cross-examined. Among them, PW1 is the Dr. Saswan Borua. he has conducted postmortem reports, and in his opinion, in my opinion, the cause of death of the deceased is due to syncope following shock and hemorrhage as a result of neck injury sustained by the deceased. Exhibit P1, PW1 is the postmortem report. Exhibit P1, sub P1P is my signature. And deposition of PW2, his name is Nipen Mura. He is the informant of this case. On oath, he says, I am the informant of this case. Accused is husband of my sister. Deceased was my sister. The incident took place about 5 months ago in my home at 5 p.m. At the time of incident, I was absent in my home. My sister, namely Suman Mura, my wife, namely Sumitra Mura, and Nabojoti, son of the accused, aged above 6 years, were present. At that time, informant was not present. I was proceeding to Namghar to return a bucket. Then I heard a hue and cry from my house. Immediately, I returned to my home and found that my sister Suman Mura was lying in the kitchen and her neck was slit. Navajoti told me that the accused came to my home and cut my sister Suman Mura on her neck with a pruning knife. Immediately, information was given to the police and police came to the spot. In the meantime, 108 ambulance was also called. My injured sister was taken to Golaghat Civil Hospital where she died. 3 days prior to the incident, the accused tortured my sister because of suspicion and then she took shelter along with her younger son in my home. After that, I lodged FIR against the accused. The FIR was written by Loknath Munda as per my person. Exhibit P2 is the FIR, is my signature. Police interrogated me. I stated all these facts before the IO. In cross-examination, he stated, my sister was married to the accused about 10-12 years ago. From their wedlock, 2 children were born. Age of the elder son is about 7 years and the younger one is 6 years. Both sons are residing in the house of the accused. We maintained a good relationship with the family of the accused. Accused is also a tea garden worker. Prior to the incident, relationship between the accused and my sister was good. I did not witness the incident. It is not a fact that I did not state before the IO that Navajoti told me that accused came to my house home and cut my sister Suman Mora on her neck with a pruning knife. It is not a fact that I did not state before the IO that 3 days prior to the incident, the accused tortured my sister because of suspicion and then she took shelter along with her younger son in my home. It is not a fact that today I disclosed falsely that my nephew Navajoti told me that accused came to my home and cut my sister on her neck with a pruning knife. My lord, in this case, informant, he himself stated that he is not an eyewitness in this case. PW3, as a 36 years, my name is Dinesh Tati. On oath, I know the accused person. I also know the informant and disease. Disease was wife of the accused. The incident took place about 6-7 months. Is about 7 months ago at about 4-5 p.m. in the house of informant. When I returning from paddy field after tying my cows, I saw that villagers were proceeding to the house of the informant. Then I heard that accused cut his knife. Then I also went to the house of the informant. When I reached the place of occurrence, the police took the accused in their vehicle. Dead body was already sent to the Bokakhat hospital. Police seized the pruning knife. I put my signature on scissor. Exhibit P3 is the scissor list and exhibit P31 sub is my signature. In cross, I put my signature on scissor list in the house of informant. At that time, accused was not present. I do not know who produced the seized DAO before police. As neighbor, I put my signature. And from this statement of this PW3, it is also clear that he has not seen the incident. He has come after happening the incident. PW4, my name is Sri Navajoti Mora, son of Sri Sanjay Mora. As the witness is only 6 years old, no oath is administered to him. Rather, I put the following question to the witness to assess his capacity of understanding and whether he is fit to make statement on. The witness has deposed in T tribe language and the same has translated into Assamese language by Sri Podum Munda, the uncle of the witness, and thereafter those were translated into English by the court. Question: what class do you read in? I read in class 1. What is the name of your school? My school name is Borbeta Kalpis. What is the name of today? Today is Saturday. How many brothers do you have? I have 2 brothers. What is the name of your elder brother? The name of my elder brother is Rupen. From the answers given by the witness, it appears that he is capable to make statement, and accordingly I recorded his statement. At present, my mother is no more. The incident took place at the house of my maternal uncle in the afternoon inside the house. At the time of incident, I was with my mother. At the time of incident, my mother was warming her body near the fire, and at that time, my father came and cut hold of my mother from backside and cut her with a cutlery knife in front of her neck. I have seen the incident. After cutting my mother by my father, my mother fell down and was reading. After the incident, my father went to his own house. Thereafter, I called my maternal aunt Rumi. Then she came there. After that, so many people arrived at the place of occurrence. Thereafter, my mother died. Earlier, I gave my statement before the Bokakhat court. Police also came to the place of occurrence. I have stated the facts for police. In cross, he said, the name of my mother was Suman. I have elder brother. I used to go to school alone. My father and mother used to do work at tea garden. It is not a fact that I was not present with my mother at the time of occurrence. It is not a fact that I did not see the incident. It is not a fact that I never called my maternal aunt. It is not a fact that I did not give any statement before the court earlier. PW5. My name is Sri Saptasri Das. Saptarshi Das. On oath. On 14/7/2022, I have recorded the statement of witness Sri Navajyoti, aged 7 years, in connection with Bokakhat case 86 of between. As the witness was 7 years old, oath was not administered upon. However, in order to ascertain, understand, to be able to answer rationale, I have put forth certain preliminary questions. After interacting with the witness, I was reasonably satisfied that he possesses the requisite rationality to depose, and subsequently I proceeded to record his statement. PW6. Gyankanto Karmakar. I know the accused person. This is an informant of this case. This was the wife of the incident took place about 7-8 months ago. On the date of incident, 5:30 p.m., when I was ready to go to market for shopping, then I heard hue and cry in the house of the informant. I proceeded to their gate. Wife of the informant told me that accused had cut his wife Suman. Ambulance came, and when Suman was taken to the hospital, then I saw her. I saw bleeding cut injury her neck. Police also came, his column cutlery and prepared scissors. I put my signature on. In cross, I do not know about the contents of the scissors. I did not see the pruning knife in the time of putting my signature in the scissors. My lord, in the deposition of PW6, it is clear fact that he has not seen the accused committing the crime. He just come after the commission of the crime and see the victim going to the hospital. PW7. My name is Babul Kurmi. I know the accused person. This is an informant of this case. This was the wife of the incident took place about 7-8. When I was proceeding to the field to take my cows, the wife of the informant Sumitra Mura made hue and cry and called some person. She also cried that she was cut. Then I entered their house and saw that Suman Mura was lying with bleeding injury in their teeth. I saw bleeding injury on her neck. Sumitra told me that accused had cut Suman. The son of accused told me that he was present and he saw the incident. I immediately informed the matter to BDP persons and 108 ambulance. Suman was living when I saw her, and after that she was taken to hospital, and the hospital she died. After that, police came to the spot. The son of the accused witnessed the entire. Police also came and seized pruning knife from the house of the accused. When I reached the spot after hearing the crying of Sumitra, then son of the accused did not state anything to us. I did not state before the IO that Sumitra told me that the accused had shot his wife Suman. At the time of incident, Sumitra was outside the house and the incident took place inside the house. She told me that she was outside the house. I did not state before the IO that police recovered the pruning knife from the house. It is not a fact that all the statements are false for which I did not state this fact before the IO. It is not a fact that son of the accused did not tell me anything about their PW8. My name is Sumit Karmakar. I know the accused person. This is an informant of the case. This was the wife of the accused. The incident took place 7-8 months. When I was returning from the market, I saw gathering at the house of accused. I saw that Suman Mura was lying in their kitchen. I saw bleeding injury on her neck. I heard from Nigan that accused shot her wife with a pruning knife. The accused kept the pruning knife below his mattress. Immediately, Suman was taken to hospital, but he died there. It is not a fact that I did not state before the IO that I heard from Nigan that accused shot her wife with a pruning knife. It is not a fact that I did not state before IO that accused kept the pruning knife below his mattress. It is not a fact that I did not state it above mentioned fact for the IO and I deposed falsely state. Then PW9. My name is Sumitra Mura. Accused Sanjay Mura is husband of my sister-in-law. Disease was my sister-in-law. Informant is my husband. The incident took place about 6 months ago at 5 p.m. at our home. At that time, I was in my home alone with deceased Suman and her son Navajyoti Mura. Accused was the husband of the. At the time, I was pulling water from tube and Suman was in the kitchen. Navajyoti was also present in the middle room of our house. I saw that accused entered our house, and after that he came out to our backyard. Then Navajyoti called me into the house and stated that his father had shot his mother. Then I rushed into our home. I saw that Suman Mura was lying in a pool of blood. I saw cut injury on her neck. Then I came out and made Juven cry. The neighbors came to our home. Then they called 108 ambulance and took her to the hospital. Later on, I heard she died. I saw a pruning knife in the hands of. 2 days prior to the incident, quarrel took place between accused and his wife. He had beaten severely his wife. As Suman was sitting on the road, I called her to her house. I called her to our house. Since then, she was residing with us. Accused was in his home on the day of incident. He came to our home and committed the crime. Police interrogated. I stated all these facts before the IO. Defense side. I do not know about the reason of the quarrel between accused and his wife. I asked the deceased about the reason of their quarrel, but she did not reply. We tried to compromise the matter. Prior to the incident, accused came to our home to return back his wife, but we did not allow. For that reason, accused was angry. The deceased also did not want to return to the house of the accused, for which accused was also angry on her. That is the cause, my lord, behind the committing this crime by the appellant, my lord. It is quarrel. Before the incident, quarrel is occurred between the deceased and the accused villain. And
The quarrel was 2 days before. Quarrel was 2 days before the incident.
yes, my
After the quarrel, the deceased had gone to her brother's place, informant's place, and was staying
Yes.
with her son. Then the accused came to the house of the paternal home of the wife,
Yes.
hacked her. The son was a witness.
yes. Prior to the incident, both accused and his wife were living happily. The children of the accused are aged about 8 years and 6 years respectively, and they are living with their uncle. He has a family and earns his livelihood by daily wage. The uncle could not look after the children because he has limited income. The incident took place at about 5 p.m. There was a darkness. It is not a fact that I did not state before police that I saw pruning knife in the hands of it. I did not state before the IO that Navajit Mora was present in the middle room of our. It is not a fact that I falsely stated that when I was pulling water from tube and Suman was in the kitchen, Navajit was also present in the middle room of our. I saw that accused entered in our house, and after that he came out to our backyard. Then Navajoti called me into the house and stated that his father has cut his mother. It is not a fact that I did not see accused Sanjay Mora at the time of incident, and Navajoti did not state anything. Then PW10, Jupitora Gogoi. On 11/7/22, I was posted at Bokakhat PS as a SI probationer. On that day, OC Bokakhat PS received an information from Sri Loknath Gupta, a VDP member over mobile phone, that one Sanjay Mura cut wife the house of his brother of the. The information was entered in our OC at Bokakhat PSDD number 220 dated 11/7/22 and entrusted me for investigation. The exhibit P5 is the extract copy of Bokakhat CSDD 220 dated 11/7/22. Exhibit P5 is the signature. Inspector Vitupam Sutia is the then OC Bokakhat. I proceeded to the place of incident along with our other staff. In the meantime, injured was taken to Bokakhat Civil Hospital. I saw that there was a blood stain on the ground of the kitchen. I interrogated the witness. On the basis of the statement of witness, I proceeded to the house of accused. I found him in his home and apprehended accordingly. As per direction of the accused, I recovered the pruning knife used in the incident and I seized the same. Exhibit P3 is the scissor lace. Exhibit P3, P33, PW10 is my signature. Today I have seen the seized pruning knife before this court. Exhibit 1 is the pruning knife. I seized the pruning knife in front of it. I recorded there that after that we returned to our police station along with accused and seized article. At police station, I knew that Suman Mura died in the hospital. Therefore, I proceeded to Bokakhat Civil Hospital. I saw the dead body of Suman Mura. Her neck was slit and found blood stain there. After that, we brought the dead body to police station. In the meantime, Nigen Mura lodged FIR. On receipt of the FIR, OC Bokakhat PS registered Bokakhat PS case number 8622 under section 302 IPC and entrusted me to investigate the matter. I recorded the statement of the informant and accused. I arrested the accused. On the next day, executive magistrate performed inquest over the dead body. After the dead body was sent to SKK Civil Hospital for postmortem, I also collected the PM report. I sent witness Navajoti Mura to the court for recording his statement under section 164 CRP. On the next day, I also drew sketch map on the place of exhibit P6 is the sketch map. P61 PW10 is my signature. After completion of investigation, I submitted charge sheet against the accused Sanjay Mura under section 302 IPC. Charge sheet exhibit 7 is the charge sheet and is the so is my signature. During my investigation, I found two eyewitnesses, namely Sumitra Mura and Novojyoti. Defense side. At 6:30 p.m., OC Bokakhat PS entered the GT of the incident. I proceeded to the place of incident at about 7. The distance between the place of incident and house of accused is 100 meters. When I prepared seizure list, the case was not registered. No signature of the accused was taken in the seizure. It is not a fact that seizure list was not prepared in presence of the accused. In
Madam,
accused,
we have gone through the depositions. You can formulate your arguments.
yes, my lord. My lord, in total number of prosecution witnesses, my lord, and in the
Is it a regular appeal or a legal aid?
I am legal aid, my
Legal
lord,
aid, no?
legal aid. And in from the statement of investigating officer, it is clear cut that in this case only 2 eyewitnesses are. That is, one is son of the appellant accused, that is Novojyoti Mora, and another is Sumitra Mora. She is the sister-in-law of the victim, and the wife of the informant. And
Yes.
as per statement of the wife of the victim, Sumitra Mora, it is also clear that she has not probably seen the whole incident, because at the time she was backward of her own home. She came to the place of occurrence when Novojyoti, that is the son of the appellant, told him that his father came to the middle room and cut his mother with a knife. So she has given a hearsay evidence to the court, to the police, that actually Novojyoti Munda has seen the whole incident. That is the son of the appellant. He is 6 years old. Then post-mortem is reported. Also, it is clear that it is that is occurred by the knife neck injury. But all this, what say about the prosecution witness is not a matter of fact, but is under section 313. The accused himself pleaded his guilty, and he stated his repentance. He stated that he has committed the crime and he has done a mistake, so he is liable to punishment for that this crime. And this appeal is filed only for the sentence of the amount, year of the sentence, whole life, rigorous imprisonment, life imprisonment. And appeal is filed to reduce the sentence.
What are the punishments prescribed for 302?
Punishment for 302, 10 years or more.
302.
10 years and more.
Please have a look.
Life imprisonment is, my lord, in exceptional case, my lord.
No,
but
no,
in
no.
this case, my lord,
Let us read. Let us not go by speculation. Read 302. What is 302? Please read 302, madam. You are in this field for a long time and you are saying 10 years or more. From where do you get the prescription of punishment? You cannot speculate punishment. What is stated in the notice?
302 punishment more for murder. Whoever commits murder shall be punished with death or imprisonment for life, and shall also be liable to fine.
So where is the 10 years thing?
Punishment, death or imprisonment for life and fine.
There are only two punishments, either death or life, and it's fine.
Yes, my lord, death or life imprisonment. My lord, if life imprisonment may be reduced, my lord, as per...
Under what prescription? Tell us, is there any prescription under 302 to reduce? Can a court give punishment which is not prescribed by law?
As per statement of the guilty plea, my lord, as
So this is the sentence. Sentence 302 is the sentence. 302 is the punishment for 300. Now the prescription is given either death sentence or life with fine. So where is the scope to reduce?
As your lord, my lord, I am trying to only to reduce the sentence, my lord.
Reduce the sentence cannot be done, which is beyond the prescription. You have to formulate your argument in a different manner.
My lord, when the accused appellant himself is stated he remorse, he repentant for his guilty, my lord. And I have nothing to argue about this matter,
No,
my
even
lord.
if you admit a guilt, it cannot be something which is beyond the prescription of law.
Yes, my
If it is, as long as it is a offense of 300,
Yes.
it is punishable under 302. The punishment might change if the offense is altered to any other offense. And in that line, you have neither argued nor we see that there are any materials.
and your lordship, from the statement of the 6-year-old son, my lord, he stated that at that time his mother was in front of the fire, my lord. She was warming her body, my lord. At that time, it was the month of July, my lord. And from the statement of the PW Navajoti, son of the appellant, it is reflected that the victim may be suffering from disease, my lord.
But
But
that was not due to disease. That was by
or ailments, my lord.
is the deaths caused by ailments.
But it is not reflected in the statement, my lord. But it is found in it is reflected in the statement of the 6 years old that my mother was warming at that time, warming her body at that time before the fire, my lord. That is in the month of July, my lord. At the month, it is the hottest period of the year, my
Now,
lord.
how is it connected with your submission?
So it is, except this, it is the presumption, my lord. In the post-mortem report, nothing is revealed, my lord, except the neck injury.
So that son has seen the father hacking his mother.
Son has said that
His 164 is also proved.
Yes.
164 is
and cut injury is only
it corroborates the substantial evidence. There is no inconsistencies.
my lord, in this connection of this appeal, I have also filed one IA interlocutory application for suspension of the sentence, and this interlocutory application may be disposed of with this limited appeal.
We are deciding the appeal. Where is the scope of? I will not either decide or decide. I will go. Is there anything to discard the evidence of the child? What is the law on child evidence, child witness? How is it to be treated?
My lord, before recording his evidence, learned trial court has examined his maturity of the understanding. When he was asked against the question put before him, he replied properly. So his statement is accepted as a maturity of understanding. So his statement cannot be ignored, and only the eyewitness, and he's in the cross-examination, nothing is rebutted, my lord. He is not destroyed, my lord. His evidence is not destroyed, my lord. And all the other witnesses are circumstantial evidence given, hearsay evidence given, and no prosecution witness has directly seen that the accused has went to the home and committed and put the knife in her neck behind the 15. And there is no hue and cry at the time of the incident. My lord. Silently, it was killing. When the victim lied in the floor, son make a hue and cry. So immediately, incident was happened. My lord, only for the statement of the guilty plea statement of the accused, my argument goes in favor of the prosecution side, not in favor of the
No, you were,
appellant side. My
you
lord.
were hinting upon reducing the sentence.
Yes.
You said that the offense was there. Commission of the offense has been proved. But if the sentence could have been reduced, so as long as the offense is stated to be under section 300, there is no scope for reducing. It is up to the executive. If he files for remission, that's a different matter. But you may have a scope to argue that it is culpable homicide not amounting to murder. On that line, will you like to make any submission? Whether we accept or not, that's a different question. But you have not made any effort for converting the offense to one under 299 and not 300.
My lord, when the accused appellant came to the house of the informant home, house of the informant,
Yes.
3 days before there was a quarrel between the appellant and the victim. And the quarrel was occurred due to the mobile that was only at the time, whole time the victim was engaged in looking the mobile. So quarrel was occurred. And 3 days before, when the victim was tortured by the appellant,
Yes.
he was brought by the informant to her home. Then she was staying with her son in her brother's. And the accused called back to her, but she was refused to come. And when he goes to the informant home, the informant and her family members, that is the brother of the victim, did not allow her to go back to her husband's.
From where do you get this?
Yes, ma'am.
From where are you making this submission?
I'm going to all the statement, my lord.
Now, who said that she was not allowed to go back? When the accused had come to the place of the informant, he was not even there.
Yes.
So from where are you making the statement that she was not allowed to go back?
Statement of a Suman Munda, informant.
Informant is by the elder brother. PW2, page 11.
Sumitra, PW9, Sumitra Mura, page number 2320.
20? PW9.
Sumitra Mura. She says 2 days prior to the incident, quarrel took place between accused and his wife. He had beaten severely his wife. As Suman was sitting on the road, I called her to our house. Since then, she was residing with us. Accused was in his home one day of incident. He came to our home and committed the crime. Police interrogated me.
Where is the fact that he wanted to take her back? He was obstructed. In the cross-examination. Prior to the incident, that is prior to the incident, accused came to her house to return back.
In cross, I do not know about the reason of the quarrel between the accused and his wife. I asked the deceased about the reason of their quarrel, but she did not reply. Actually, he did not reply. We tried to compromise the matter. Prior to the incident, accused came to our home to return back his wife, but we did not allow. For that reason, accused was angry. The deceased also did not want to return to the house of the accused, for which accused was also angry on her. This is the reasons, factors, that the appellant became angry, and on the day of the incident, he rashly go to the house of the informant wife, and commits the crime.
Okay, anything else?
I have nothing to say, my lord.
Any decision you'd like to cite?
Your lordship, if any possible, to correction of the life of the appellant from the of the
Any decision you'd like to cite of the Supreme Court?
the ground of appeal is, my lord.
Yes, Madam Begum.
As is based on, there are two eyewitnesses subject, and moreover the accused has pleaded guilty by himself. Thing is that there is no such incident that due to the heat of movement or something, there is a he have done this for which the sentence may be good. He have done with full planning, lord. Because prior to the incident, 2 days before, lord, there was a fight, and after 2 days, he normally came and the incident occurred. There was no such witnesses who have said that again such quarrel was there. Due to heat of movement, somebody may do, nothing is there. Everything was in a pre-planned manner. And lordship, regarding that child, little discrepancy that warming the body, because both the witnesses, both the eyewitnesses said that she was in the kitchen. And regarding the child eyewitness, as he is lordship, before lordship taking his statement, lord, he was totally relaxed and he was put the question that he understand. And lord, there is nothing such thing that it's tutorial. What he have said, he have said. The other hand, lordship, it is his father, lord. Child will not go against the father. And 164, lord, it corroborates 161, 164, lord.
Yes. Okay. Lose it, no? Lose it.
My humble appeal.
Up to 9? B.R.A. Sultana, Legal Aid Council. Appellant. A. Begum, APP. Conclude. Yes, Madam Pathak, you have something? Pathak, which case do you have? Interesting case. We did not find any interest. (313) per se is not evidence. It can be used for corroboration, and only based on an admission in 313, there cannot be a conviction. But here we find eyewitnesses there, and once it comes within the ambit of 300, the prescription of law cannot make any other sentence. That was not even argued. Even if it was not argued, we tried to look into that matter. The quarrel had happened 2 days before.
Prior to
2 days before. If you have read the Nanavati case, famous case, almost the same transaction. Still, it was held that he had gone, put them in a cinema hall, come back, think over, then killed. Premeditated. Okay.